I seek your lordship's kind indulgence for accommodation today and tomorrow because I am indisposed due to ill health.
All right.
Matter any day next week, subject to your lordship's kind convenience.
All right. 31 and?
Only 31.
I see. 31. All right. Counsel for the petitioner is indisposed today. List on 23rd August. Right.
May I seek an earlier date, my lord? Maybe any time earlier, my lord. May I pray, my lord? Any time earlier, my lord. Next week, next month, any time, my lord. Subject to your lordship's board, my lord.
To be known in April or May. It can be only in May, sir.
As your lordship pleases, my lord.
10th May. 10th May.
10th May. I'm deeply obliged, my lord. I'm deeply
obliged.
Supplementary list, fresh submission item number 1.
My lord. My lord, the status of the case is still awaited from the department.
It's 2011 matter, sir. No, we won't keep adjourning it, sir.
Whether this matter is
Challenged or not. We presume on the basis it's not challenged, sir.
And my lord, the status is not yet.
That's all right. And we can't wait
So
endlessly.
kindly
The 2011 matters. Can't wait endlessly. You see, the challenge in the present appeal is to an order dated 10th December 2010 of the Sistat Eastern Zonal Bench, Kolkata. In allowing ST appeal number 170 of 2010 filed by the SSC. Paragraph. The issue before the Sistat was regarding the justifiability of a demand of rupees 654,191 of service tax raised on the SSC. Disallowing the credit availed on input services attributable to the quantity of iron ore fines and coal fines cleared by the SSC. Paragraph. Before the Sistat, UTA services utilized for bringing the inputs at the time of clearing them. Full stop. Reliance had been placed inter alia on the decision of 3 decisions of the Sistat itself, one of them being Chitrakoot Steel and Power Private Limited versus Commission of Central Excise 2008-10 STR 118 bracket TRI-Chennai bracket. Paragraph. These decisions of the Sistat did hold that since there is no specific provision for reversing the credit involved on input services utilized for bringing in the inputs, no liability attached, no service tax liability can attach, can be enforced. Full stop. Paragraph. On the previous hearing, this court had inquired from counsel for the appellate department whether the department had challenged the order of Sistat in Chitrakoot Steel and Power Private Limited, Supra. Full stop. By the order dated 1st December 2022, this court had granted 2 months' time to the department to ascertain the above fact. Paragraph. Today, counsel for the department states that he is still unable to ascertain the fact. Paragraph. Considering that this is an appeal of 2011, the court does not consider it appropriate to grant any further time for this purpose. Full stop. The court will proceed on the basis that the department has accepted the decision of the tribunal in Chitrakoot Steel and Power Private Limited, Supra. In that view of the matter, the court does not find any substantial question of law arising for determination of the present appeal. The appeal is dismissed.
Supplementary list item number 2.
My lord, the question of law is at page 14, my lord. Whether on the facts and in the circumstances of the case, the tribunal was legally justified in disallowing ITC on explosives, holding that explosives used in mining operation for blasting of earth surface in order to extract iron or lump is not included in the meaning of section 225. My lord, similar matters are
Pending, is it?
kept pending, awaiting for the Supreme Court judgment, Honorable Supreme Court.
Awaiting judgment of Supreme Court.
My lord.
Same order. List this revision petition after disposal of the aforementioned matters by the Supreme Court of India, along with STREB 50 of 2015. Stop liberty is granted to the parties to mention the petition for listing after the judgment of the Supreme Court.
Item number 3.
But here the opposite party number 4 to 10 have encroached the Cuttack Municipal Corporation land, and my lord, that is adjacent to the canal, by which the Cuttack Municipality had filed civil suit. There, my lord, they lost, and thereafter they filed title appeal. In the title appeal, it was allowed, and there is an undertaking by the opposite party that they will demolish within 3 months, failing which the municipality will execute the order of the title appeal. Against that also they have filed second appeal. Second appeal also opposite party number 4 to 10 lost, and also they preferred SLP also. Everywhere they have lost. Now 2011 is the last Supreme Court's order, SLP order at page 44, my lord. They have lost it everywhere, but they are not, in spite of their undertaking given in the court that they will demolish the structure within 3 months. Still, my lord, they are not demolishing the matter, and now in the meantime, the municipality has filed execution case in 2019. 2011 is the last order that is passed by the Supreme Court, Honorable Supreme Court. And after 8 years, now in 2019 they have filed execution of the decree, and till date they have not demolished the structure.
But when there's an execution case proceeding pending, why should we entertain denial and all that?
Last 4 years they have not filed these judgments of the Honorable High Court and Supreme Court and title appeal order, and just they are lingering the matter. I have filed also enclosed entire order sheet. They are taking time for last 4 years.
But we can't have another proceeding parallel to that. What is the number of the execution case?
Execution case is
That your lordship can direct the trial court to expedite that.
Correct.
80 by 2019.
It is stated that execution case 80 by 2019
At
has
page
been
not
instituted by the state,
Cuttack Municipal Corporation.
CMC.
by the CMC for eviction of opposite parties 4 to 10
10 million.
from the property in question, pursuant to the judgment of this court in second appeal,
Million.
which has been affirmed by the Supreme Court, against the said parties. Full stop. Paragraph. The grievance
Let
of the
me say
present-
that it is pending in the court of the second additional. First additional civil judge, senior
Senior
division.
Yeah. Grievance of the present of the petitioners is that although the said execution petition is pending in the court of the
First additional civil judge,
first additional civil judge,
senior division.
Senior
Cuttack.
division, Cuttack.
civil judge senior division, Cuttack. The relevant orders are not being placed before it by the state authorities, and only
CMC.
by the CMC, and adjournments are being sought. Paragraph. Since proceedings are already pending in another court, it would not be proper for this court to entertain parallel proceedings. Full stop. A direction is nevertheless issued to the CMC to ensure that all the relevant orders, including those forming part of the present petition, are placed before the said
Yes.
court of the senior civil judge, first additional senior civil judge, Cuttack, in execution petition number
80 by 2019.
80 by 2019, positively, if not already done, within a period of 8 weeks by filing an appropriate application in those proceedings. Paragraph. The court clarifies that it has not expressed any view on merits.
Lordship, kindly have glanced to the photo I have given. What happened to the Lord the canal?
It's all right.
Lord,
Your lordship
entirely
can-
blocked.
Your lordship
Sorry.
can direct the
By
court to expedite the execution.
The CMC will also request the concerned court to expedite the matter. Paragraph. A copy of this order be sent to the Commissioner CMC as well as to the court concerned. Forthwith.
Obliged.
The petition is
Reply.
disposed of. Right.
Supplementary list item number 4.
But I have filed certified copy of the orders that may be returned by substituting the, because Lord, that will required by
The
the,
originals of the annexures be returned subject to being substituted with the attest for.
Obliged.
Item number 4.
Well, item number 4 and 80, those are all connected matters with the which your lordship have fixed at 2 p.m. in the
Order.
special.
Order. Take up at 2 p.m. 4 and 80.
Yes, madam. Obliged, madam.
Item number 5.
Item 5 and 6, Lordship, I will approach appropriate forum, Lordship.
All
5 and 6, appeal is there.
All right. Counsel.
Copy is
Petitioner
all
seeks
right.
leave to withdraw the present petition with liberty to file statutory appeal against the impugned order. And against the, no, appeal, this is only a notice.
Lordship, notice, Lordship, appeal is there. In the meantime, let's the 2020 notice, subsequent.
No, you say to seek appropriate remedies as may be available to the petition in accordance with law. If such proceedings are instituted not later than 3rd April 2023, then it will be considered in accordance with law by the forum concerned. And appropriate orders be passed within a period of 4 months thereafter. No further directions are called for. The court clarifies it is not expressed in even the matter. The same order in 6 also.
Lordship.
Right.
Item number 7.
When, my lord, say dispute can be resolved through arbitration, the clause for arbitration at 25.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to seek other appropriate remedies.
Arbitration already in.
No, whatever, as available to the petition in accordance with law. Disposed of is withdrawn with liberty spread. Right.
Obliged.
Item number 8.
My lord, in item 8, my lord, on 4th of October 2021, your lordships, a search, seizure and seizure operations conducted under section 67 of the GST Act, your lordships. And during such investigation, your lordships, the physical stock taking was done and it was a comparison made with my book balance, your lordships. And they found that an allegation that there is a shortage of goods, your lordships. On such shortage of goods, your lordships, the goods have been under confiscation under section 130 of the GST Act, and fine in lieu of confiscation has been made under section 130 subsection 2 of the GST Act. My issue, my lord, that when the goods are not available in the premises, how the goods can be confiscated and fine in lieu of confiscation can be imposed, my lord. And my lord, also in furthermore, in the case of Gupta distribution and STRB 2 of 2018, followed by the Christian Pusti, has held that unless there is a finding that the goods have been sold, that the dealer can be brought to the burden with the tax liability, my lords. This is a challenge made to under section 130 of the Act, your lords, order passed.
No, but this demand of orders appealable.
Revisable, man. Revision is there.
Revision is
Revision are appealable, lord. It is appealable.
Revision.
It is appealable, order matter.
No,
But my
there is no
submission is, my lord, that
GST. There is no application for revision under GST by the parties.
no appeal.
It is appeal.
my lord is appealable, order. My lord, my only submission is that when the goods are not available, how can the confiscation
All
of
right.
fine lieu of confiscation impose, my lord?
So pointed out. Sir. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned demand notice. The impugned demand by way of an appeal, as provided in law, if such appeal is filed not later than 3rd April, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition. will be considered in accordance with law by the appellate authority.
My lord, in time bound manner, my lord.
The court clarifies that it is not expressed any matter.
Obliged, my lord.
Item number 9.
Your Lordship, I am challenging notice under section 148 in this case, my Lordship. And Your Lordship, before taking Your Lordship to the matter, Your Lordships have taken views in this based on Supreme Court decision in the case of Anshul Jain. Your Lordships have taken followed that decision. But Your Lordship, I want to submit before Your Lordship that yesterday Honorable Supreme Court has pronounced one decision in the case of Godrej Sarali. In the case of Godrej Sarali, Your Lordship, the matter was related to reopening only. If Your Lordship can kindly go to para number 3 of the decision.
Godrej
Sarali, Your Lordship. Godrej Sarali Limited. Yes. Paragraph
2010 matters, huh? This is the 2010 matter. It has nothing to do with 148A at all.
No, Your Lordship, it was decided yesterday, and this relates to reopening under the Punjab and Haryana VAT Act, Your Lordship.
See, this is all general. Specific to 148A is Anshul Jain, which has been affirmed by the Supreme Court. So we have to follow that, sir.
Your Lordship, my humble submission.
See, you won't find. Let's point out in Godrej Sarali that Anshul Jain order of the Supreme Court has been set aside.
No, Your Lordship,
or overruled. Overruled.
No, Your Lordship, Anshul Jain has not been referred. My humble submission, Your Lordship. In Anshul Jain, the challenge was made on merits to the order under section 148 AD, sir. Your Lordship, I have not challenged on merits, Your Lordship.
Yes.
My challenge is limited to limitation, Your Lordship, and Your Lordship have followed
with all that, sir. In our order, Kailash Kedia, we dealt with limitation also.
Yes.
We have said all those pleas can also be urged in the appropriate stage.
Your Lordship, if I may humbly place before Your Lordship 2 decisions which Your Lordships have pronounced in the case of Vishal Ferro Alloys and Bajrang Steel, where in identical cases Your Lordship have admitted and they are listed in the month of February 2023. My humble submission, Your Lordship.
Those were just separated out, sir. That's those are just orders.
Yes, Your Lordship.
They're not final orders.
No, Your Lordship. So the point raised is limitation, Your Lordship. If kindly, can I take you
this is already, so when we passed these 2 orders, Vishal Ferro Alloys and Bajrang Steel, if I remember right, we had not pronounced the Kailash Kedia order.
Yes, Your Lordship.
Kailash Kedia order came later. It's January 2023 order.
Your Lordship, yes. Kailash Kedia's case was pronounced on 1st of December 2000.
1st of December, correct.
Yes, Your Lordship. Yes, Your Lordship.
Yesterday there was a subsequent order because our attention is drawn to a later order of a different bench of the Supreme Court.
Red chili. Yeah, red chilies, yes.
No, not this, sir. Red chilies.
Yesterday's Lordship passed order in
we had passed, after considering red chilies, we had passed another order. Do you have that order? The 7th. After Kailash Kedia, we passed another order.
Sieve metallics.
Sieve metallics, yes.
Sieve matter.
Yes,
sorry.
Sieve metallics.
Yes.
Where is that?
But yesterday I had submitted, I could not get.
Sieve metallics.
Your Lordship, my humble submission, if I can place before Your Lordship, that the challenge here is to the very jurisdiction of the assessing officer.
Correct. All that, sir. We considered all that.
Yes.
10th January, Shiv Steel. Shiv Metallics or Shiv Steel.
Yes.
See, in view of the order passed with this court in Kailash Kedia, as well as the subsequent order dated 10 January 2023 in Shiv Steel. Shiv Metallics. The court does not entertain the present petition at this stage. Nevertheless, it will be open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage. At an appropriate stage. Full stop. The petition is accordingly not entertained and is dismissed with the above observations. All right.
Deeply oblige you.
All right.
Item number 10.
10, my lord. Entry tax interest matter, then maybe
2 o'clock.
To the second list.
All right.
Item number 11.
May I please, my lord?
the petitioner wants to surrender the OS subs and the representation is pending before the collector Ganjam. My lord, Annexure 4 is my lord's order is covered with. My lord, I direct the collector Ganjam to surrender my license on Bhikapada and Lakhampur license up under Langaleshwar Gram Panchayat.
My lord, surrendering a license, it is only under Rule 49 that he has to deposit the all dues, area license dues, MGQ, then only, not that any time anybody will come with a surrender application, the state will accept it. So if that is why perhaps this, I am not filed.
Not entertained.
Your lordship may direct the collector that
The collector to take a decision within a period of 6 weeks, which is
subject
pending.
to compliance of
The grievance, the
rules.
limited grievance of the petitioner at this stage is that the petitioner's application dated 19
Annexure
December
1.
2019, offering to surrender the Lakshmanpur and Bikapada branch OS shop licenses under the Langaleshwar main OS shop in district Ganjam with effect from 1st April 2020 has not yet been considered by the collector Ganjam. In terms of section 49 of the Orissa
Excise Act
2008 bracket OE Act paragraph, Mr. D.K. Monthi, learned AGA, points out that for the surrender application to be considered, the petitioner would have to comply with certain requirements. And only then the application can be considered. Paragraph, a direction is accordingly issued to the collector Ganjam to examine the above application of the petitioner, and if the petitioner has satisfied all the complied with all the requisite formalities, then to consider the such application in accordance with law and communicate the decision to the petitioner.
Hello, collector cannot take the decision. Collector will recommend it
and
to the
make a recommendation to the government of Orissa in that regard, not later than 1st May 2023.
My lords, I may pardon. The Sarpanch of local Sarpanch and also public has complained. That's why I am running this up. That line be added. I have been giving you my representation.
We don't have to get to the merits of all that, sir. No further directions.
Within a period of 6 weeks, my lord. In the earlier order, Annexure 4, my lord has directed to take a decision within a period of 6 weeks from
You've said 1st May now.
My lord, I may pardon.
You've said 1st May, sir.
My lord, obliged.
Item number 12.
Well, here I have assailed the order of the Honorable Single Judge. It arises as a matter I would, with regard to Odisha Service and Settlement Act. Lordship may look at the impugn order. I may take my Lord's kind attention to the impugn order.
Yes.
It is at page 85.
Yes.
It starts from 83. Your Lordship may look at 86. The Honorable Judge's verdict is there. Lordship got it.
Yes.
Here my point would be, when there is a prima facie case in my favor, the Honorable Judge should have decided the matter himself.
No, you had a remedy of remission. So
my lord, that is not a remedy forum in the statute, my lord. If your Lordship will look at section 32 of the Act, may I take my lord to section 32 of the Act?
Yes. Survey and settlement. Yes, please. Power to
call for and revise proceeding of revenue officer. The Board of Revenue may call for the record of any proceeding, any officer from whose decision no appeal lies, if such officer appears to have been exercised a jurisdiction not vested in him by law, or to have failed to exercise a jurisdiction so vested, or while acting in exercise of his jurisdiction to have contravened some express provision of law affecting the decision on the merits where such contravention has produced
a serious miscarriage of justice, and the Board of Revenue, after hearing the parties, if they attend, shall pass such order as it deemed fit. It's a suo motu power, it's not a forum. Forum revision is 15(1)(a) and B. Your Lordship will look at the act.
No, but somebody can file an application for.
Well, here your Lordship may look at the fact of the case.
Yes.
From that order itself.
Yes.
Paragraph 4. However, the contention of the erroneous counsel for the petitioner is not acceptable. Holding, it is further seen that petitioners have a good arguable case for their consideration, as it is contended that their predecessor, late Saraswati Rai, has died in the year 87, and the order of the opposite party number 2 and opposite party number 4, which were impugned before the Honorable Single Judge, have been passed in the year 2013 without bringing the legal heirs to the record. However, the petitioners has alternative forum to agitate their grievances. This court is not inclined to entertain the. My submission was that the initiation of the proceeding, revisional proceeding, is without jurisdiction, and the consequential order of remand is also without jurisdiction, being initiated against a dead person, and order was passed against a dead person. No notice to the legal heirs, nothing else. So my submission before my lord would be limited that Honorable Single Judge should have remanded the matter to the Honorable Member for consideration of the revision. Now I shall go to the, again file the appellate order before the revisional court, who will again decide the matter. So it is a multiplicity of proceeding.
No, only the Single Judge says you have a revision, remedy of revision application, so I'm not dealing with it. How is it multiplicity?
My lord, both the orders are challenged. First of all, your lordship, the case is that I filed an original case that is called objection cases that were allowed then on appeal. After long lapse of time, appeal was dismissed by the state. Then after long lapse of time, this section 32 revision was filed before the member Board of Revenue against the dead person. Then the impugned order was passed, remanded the matter. The remanded court also did not made the legal heir parties and not proceeded. Now I impugn that both orders before the Honorable Single Judge. He should have remanded the matter at least to the revisional court, giving me opportunity and heard the matter afresh. Or my submission in the alternative.
What has happened? Here, you have been sent back to the revisional court only.
No. He has been advised to file an revision on the second. Now he is saying that the Honorable Single Judge should have so much sent back the file to the member Board of Parties.
There is only a technical thing that.
No difference.
Yeah.
Because in the meanwhile, 6 years passed. If you would have approached the member Board of
Section 32 power was exercised after 12-13 years.
You pointed out as a ground, sir.
Now,
that will be one of the grounds of revision.
My lord. My grounds of revision that it is against the dead person. My predecessor was a party.
Right.
Now, after 13 years, he was dead in 87.
Yes.
2013, the revision was filed. 2013, without issuing notice or without adding us as parties, the revision was allowed and matter was remitted. Then remanded court also didn't take any step to add this legal parties and pass the order.
Last time adjournment was granted so that you could examine whether a revision petition has to be suo motu or somebody can file.
That is 16th August 2007.
That I was arguing.
Whether the suo motu power is there or party can approach directly to the member. But so far as section 32 is concerned, if your lordship will read this statute, there is no bar to approach by any, there is no bar.
Correct. So somebody can file an application.
Somebody can, and according to my experience, I have seen many cases filed before the member Board of Revenue under section 32. So he is more.
Only one answer, madam. The language used was may. It's a suo motu power. He may, being the highest authority of the revenue hierarchy, can exercise that power. That cannot be a forum available to a party.
Yeah,
my submission would be this to the my lord.
That is a forum available, and if your lordship will.
And my lord, your lordship will look at
several cases filed section 32 before the member Board of Revenue, and they are entertaining. But it is only a technical dispute which my lord is raising. Whether the court will remand or he will invoke that jurisdiction, your lordship can direct the petitioner to file. He will entertain it.
The challenge in the present writ appeal is to an order dated 29th March 2017 passed by the learned single judge disposing of the appellant's writ petition civil 1968 of 2017, 1768 of 2017, relegating the petitioners to the remedy of a revision petition under section 32 of the Odisha Survey and Settlement Act 1958 bracket OSS Act bracket. Paragraph. The background facts are that the above writ petition was filed by the petitioners to challenge an order dated 27th May 2013 passed by the member Board of Revenue in an application to section 32 of the OSS Act in OSS case number 335/2013 and the consequential order dated 29 June 2013 passed by the additional sub-collector cum additional settlement officer Puri in remand OSS case number 335 of 2013, allowing the appeal of the state of Odisha and directing the quashing of the recording of the names of the petitioner's mother with respect to the land in question. Paragraph. A perusal of the impugned order of the land, you say, while directing notice to issue in the present petition, present appeal. No, you just said not while directing. On 16th August 2017, this court stayed the operation of the impugned order of the land single of the order dated 29 June 2013 of the additional sub-collector, come additional settlement officer, Puri. That stay has continued till date. Paragraph. Counsel to the petitioner urges that under section 32 of the OSS Act, there cannot be any application filed for invoking the revisional jurisdiction of the Board of Revenue because it is a single quotes suo motu unquote power. Stop. He further submits that the learned single judge ought to have itself remanded the matter to the Board of Revenue instead of requiring the appellants to file such an application. Paragraph. Mr. D.K. Manthi, learned AG, on the other hand, points out that there is nothing in section 32 of the OSS Act that prohibits the filing of an application by an agreed person seeking to invoke the suo motu jurisdiction of the Board of Revenue. Paragraph. Indeed, the perusal of section 32 of the OSS Act reveals that while it does talk of the suo motu power being exercised by the Board of Revenue, it does not bar the filing of an application under that provision to invoke the jurisdiction of the Board of Revenue. Paragraph. In that view of the matter, the court is not inclined to interfere with the impugned order of the single judge. Full stop. The interim order passed by this court is hereby vacated.
16th August
Full stop.
2017.
Will now prefer the revision petition before the Board of Revenue against the order dated 29 June 2013 of the additional sub-collector come additional settlement officer, not later than 3rd April 2023. Full stop. If such appeal is filed along with by that date, along with an application explaining the delay on account of the present petition, then it will be taken into account by the Board of Revenue while examining the revision petition. Full stop. Further, if such revision petition is filed within the time stipulated, then till such time the Board of Revenue passes an interim order. The interim order passed with this court on 16th August.
My lord, may I request one thing to your lordship? We have filed an application for vacation of the stay order because for this stay order, the entire village we are unable to distribute the patta. So stay order may be confined to the case of the petitioner only.
We say will continue, confined to the case of the petitioners, till an order is passed thereon by the Board of Revenue. Paragraph. No further directions are called for in the present petition. It is disposed of as such.
I pray your lordship may direct for reporting of, because there is lot of confusions in trial court also so far as the jurisdiction of
Section 32.
that may be taken care of by this list.
Supplementary list item number 13.
Except this issue of non-substantiation of notice on the some of the respondents, point involved here before lordship is very limited. It's a trivial issue. But the notices, Lord, subject to lordship permits, I can place it in a minute. What is the issue here? The issue here is that in the year 96, an order against me was passed by the deputy director. Lord, challenging that order, I filed the revision in 97. 97 itself. That is 150 of 1997. Now, on account of bifurcation of jurisdiction, that revision was transferred to some other court and renumbered of the year 2003. Am I clear, my lord? Now, the revisional authority passed an order in my favor. Respondents challenged the order before this honorable court, before the honorable single judge. Now, in the revisional order, there is reference that the revision was filed in 97. On account of bifurcation, it is renumbered as 2003. But the honorable single judge, taking that 2003 only, dismissed, allowed the writ petition saying that it is filed 7 years. That's the short point.
And the petitioners before the honorable single judge are the respondents. They are not noticed. So I think it is not.
Some of them are noticed, some of them are absent. That's the noting. That's the noting.
So it will not be.
They can anyway appear there, sir, before the single judge.
Yes.
It will go back. The challenge in the present writ appeal.
You'll also kindly see. Kindly see the counter of the respondent. Lords, kindly see for a minute. They have admitted that a delay of 7 years.
How can
they have admitted that? Kindly see the counter. You'll also kindly see.
Lord, what is the question of admission? My lord,
1096. You'll also kindly
Mr. Mahanti is saying something. Kindly see, my lord, the revisional order. Page 48, kindly see. There can't be such a submission which is available on record. 1 second, Mr. Mahanti. In that case, let me show it. Kindly see, my lord. Annex 3 kindly be seen, my lord, first. The notice in the revision case, page 45. Lord, how can it be said that it is filed in 97? Kindly see, my lord. Is Mr. Mahanti saying he filed 97? Kindly see page 45.
You'll also kindly see
1 second. Let me show it. Kindly see page 45, my lord.
Yes.
Lordship will see the revision case 350 of 97 by 157 of 2003. Is that there, my lord? Then Lordship may kindly see the revisional order. Even if I don't know what is the admission he is saying, my lord, kindly see, my lord. The revisional order, kindly see, my lord, page 48. How can this be obliterated? How can this be ignored? In pursuance of Government Revenue Department notification number 24, the revision consultation 350 of 97, 349 of 97 were transferred to my court from the Court of Commissioner and renumbered as 157 of 2003. Kindly see the order passed by the honorable single judge.
You'll also for a minute, you'll kindly see the counter. Either day chart.
Kindly see, my lord, page 74.
1096.
Page 74, para 8. One second, Mr. Mahanti, 1 second. Kindly see, my lord. Attall can be sustained, para 8, my lord. Reading the aforesaid provision leaves no doubt that revision should have been filed 90 days from the date of the order by person. There is no dispute that impugned order was passed by the appellate authority in 97. Revision 57 of 2000 has been preferred. 2003, there is delay of 7 years. But can't be sustained.
You'll also see page 14 of the counter. You'll also kind of 29, 10, 96.
Where is the counter?
Which counter?
That filed before the writ application. In the writ. It is filed.
Counter. Yes.
Yes. You'll also kindly see 29, 10, 96. First date chart. Both got it, Pella?
Para?
29, 10, 96. First column. That date chart. Page 14 of the counter.
Page 14.
Yes, of the counter. 1-4. 1-4 is the counter.
You've overwritten so many of those page numbers. So. What's the date of the date chart?
That is 29/10/96. 29/10/96.
Yes.
Both the appeals were heard and disposed of by the common order. Got it when last. The deputy director consultation allowed the claim of the appellant in the both the appeals. He also accordingly directed the constitutional officer to correct the records after making field inquiry. The appellate order has not been filed any of the writ petition. The consolidation officer passed an order on 26/5/97 carrying out order passed by the appellate order. This order of the consolidation officer has been annexed as Annex 9 to WPC number so and so. Thereafter, also next 2003.
Whom are you appearing for?
I am the respondent one.
You have skipped. The whole problem is from 1996, you skipped to 2003. There is something filed in 97.
Yes.
You have not noticed the date at all.
What manner that revision is not maintainable? Because
when was it filed is the question, sir. Whether it's maintainable or not is a different point. It was filed in 97.
The admitted whether you're also can ask whether there is admitted delay or not. If there is the filing
There's no
the revision.
admitted delay, sir. This is an order of 96 challenged in 97.
After that, there is also delay, my lord. Yeah, he has not filed the delay petition.
What is the delay?
Case is, my lord,
What is the delay? What is the delay according to you?
Maybe pardon to.
That is 125 days delay.
But can't be 7 years.
Even accepting, suppose admitting.
Then that is on the face of it in error, then it has to go before a single judge back. On the face of it, the single judge thinks it's a 6 years, 7 years delay. The single judge has taken 2003 to be the year of filing of the revision.
He has to file the limitation. He has not filed the limitation petition.
He has. What are you saying? The revision petition number also he read out to you now. It's a 1997 revision petition.
The fact is that revision is not maintainable. Because
don't jump from one thing to the other, sir. Kindly follow what is being asked.
Yes, sir.
We are not on whether the 1997 revision petition is time barred. The single judge was of the view that the 2003 revision petition was time barred.
I am admitting same.
So if you are admitting, then it has to go back.
There is also delay of 45 days.
So it has to go back
90 days.
So that will have to be considered by the single judge.
Yes, you're lost.
So the challenge in the present writ appeal is to an order dated 6th February 2017, passed by the learned single judge. Sorry. The order dated. Yeah, 6th February 2017, passed by the learned single judge. Allowing writ petition civil 3618 of 2012 filed by the opposite respondents 1 and 2. And thereby setting aside an order dated 22nd September 2011 passed by the Additional Commissioner, Settlement and Consolidation Odisha in RC case numbers 157 and 158 of 2003 under the Orissa Consolidation of Holdings and Prevention of Fragmentation of Land Act 1972 bracket OCHPFL Act bracket. Paragraph. While directing notice to issue the present appeal on 4th February 2019. No, paragraph. The challenge in the present writ appeal is also to the subsequent order dated 31st October 2017, passed by the learned single judge, dismissing review petition number 33 of 2017, filed by the present appellants, thereby declining to review the judgment above judgment dated 6th February 2017. Paragraph. While directing notice to issue in the present writ appeal on 4th February 2019, this court stayed the aforementioned judgment dated 6 February 2017 and order dated 31st October 2017 passed by the learned single judge. Paragraph. This court has heard the submissions of Mr. P.K. Rathil and counsel for the appellants. And you are appearing for respondents 1.
Yes.
And so learned counsel appearing for respondent 1. Paragraph. The background facts are that the present appellants you see, the background facts are that during a consolidation operation in relation to properties in LR plot number 1853 bracket P,
yes,
of an area of AC 0.06 decimal in LR Khata number 417.
Subject matter of objection case number 4060.
In village Haripur, is it?
Beg pardon me?
In village Haripur.
Right.
PO Samsarpur, PS Mahanga, District Cuttack.
Yes.
A draft record of rights was prepared in the name of the present appellants.
Yes.
Full stop. The respondents 1 and 2 then filed an objection.
4060 of 92.
To the draft ROR, being objection case number 4060 of 1992.
Right.
Contending that the property question should be recorded in their favor on the basis of a Vibad Bhanjan Patra dated 27 January 1981. Full stop.
Yes.
The consolidation officer bracket CO Chatia allowed the objection case in favor of respondents 1 and 2, against which the present appellants preferred appeal case number 83 of 1995, which came to be dismissed on 29/10/1996
and remanded
by the Deputy Director Consolidation, Range 1, Cuttack.
and remanded back. This is the cross of the case. That is remanded back. And that was adjudicated by both the parties before the in presence of both the parties. They are straight away file the revision.
No.
When the order has been final, they are straight away.
The aforementioned order of the Deputy Director was challenged by the present appellants by filing revision case number 350 of 1997 in the Court of the Commissioner Consolidation, Cuttack. Paragraph. By virtue of a notification dated 24th December 2002 of the Revenue Department, Government of Orissa, the aforementioned revision case number 350 of 1997 to transfer to the Court of Additional Commissioner, Settlement and Consolidation, and got renumbered as RC number 157 of 2003. Full stop. A transfer notice was also sent to the present appellants. Full stop. Paragraph. By judgment dated 22nd September 2011, the said RC number 157 of 2003 came to be allowed by the Additional Commissioner, Settlement and Consolidation, Cuttack. Thereby setting aside the order dated 29/10/1996, passed by the Deputy Director Consolidation in appeal case numbers 83 and 86 of 1995. Stop. In effect, the order of the CEO dated 25th March 1995 in objection case number 4060 of 1992 was also set aside. And it was held that the plot in question would stand recorded in favor of the present appellants. Paragraph. Agreed with the above order dated 22nd September 2011 in RC numbers 157 and 158 of 2003. Respondents 1 and 2 filed writ petition civil 3618 of 2012 before the learned single judge. Paragraph. One of the contentions raised was by the respondents 1 and 2 before the learned single judge was that the revision cases were themselves barred by limitation.
Yes.
Full stop. It was submitted that since the appeals were disposed of on 26th October 1996, and the RC cases were, and the revision cases were preferred in 2003, it was well beyond the period of 90 days limitation period under section 36 of the OSS Act. Full stop. The specific contention was that, open quotation, the revision for being filed after 7 years should not have been entertained and should have been dismissed on the ground of limitation alone. Full stop, unquote. It was pointed out that there were no applications for condonation of delay accompanying the revision cases. Paragraph. The learned single judge has, after setting out section 36 of the Act, concluded that, open quotation, there is no dispute that the impugned order was passed by the appellate authority in the year 1997, and the revision case number 157 of 2003 has been preferred in the year 2003. And therefore, there is a definite delay of 7 years in preferring the revision, unquote. Paragraph. Clearly, the above conclusion was based on an erroneous noting of the factual position, namely that the revision case was initially filed in 1997 and was numbered as RC case number 350 of 1997, which was later transferred to the court of the additional commissioner, and at that stage renumbered as RC number 157 of 2003. Full stop. The connected revision case 349 of 1997 was renumbered as RC number 158 of 2003. Full stop. Paragraph. In view of the above erroneous noting of the fact, the learned single judge fell in error in setting aside the
order in the counter.
Dated
Basically, on the counter is his lordship's
22nd September 2011 of the additional commissioner. And in effect, full stop, thereby the learned single judge had no occasion to examine the correctness of the said order and merits. Paragraph. The review petition filed by the petitioners pointing out the above factual error was also dismissed by the learned single judge by the second impugned order dated 31st October 2017. Paragraph. Having heard learned counsel of the parties, the court is satisfied that there is an error apparent to the face of the record of the impugned order dated 6th February 2017 of the learned single judge, which ought to have been corrected by allowing the review petition filed against it by the present appellants. Full stop. In that view of the matter, both the impugned judgment dated 6th February 2017 as well as the order dated 31st October 2017 passed by the learned single judge, allowing writ petition civil 3618 of 2012 and dismissing review petition number 33 of 2017 are hereby set aside. Full stop. The order dated 6th February 2017 will stand recalled, and writ petition civil 3618 of 2012 is restored to the file of the learned single judge for being dealt with on merits.
Yes.
Full stop. The said writ petition will now be listed before the roster bench of the learned single judge on 17th April 2023, on which date the parties will appear. The learned single judge is requested to proceed with hearing the writ petition on merits and endeavor to dispose of the writ petition within a period of 4 months thereafter. The writ appeal is disposed of in the
Date, my lord.
23rd.
17th April.
17th April. 17th April 23. But one just observation may be required. This 2A to 2D who are not noticed here, the notice process be completed there. Let them be given opportunity of hearing because their address is.
All right. Since the response to A to 2D have not been served notice in the present writ appeal, the learned single judge will proceed after ensuring that they are duly served in accordance with law.
Yes. Correct.
But they are the writ petitioners there.
They are the petitioners.
So that's the.
They should
there will be no notice to them.
The original person is dead.
So then let the single judge proceed in whatever.
The right to sue is survived.
No, they'll have to file a substitution application for petition number 2.
In fact, they have been substituted here.
So it's up to them to what.
Let them.
4 months.
They will have to file application there.
You say dispose of as expeditiously as possible. All right. All right.
Item number 14.
My impugned order is at page 116. At the UGC matter that taking into account that Alok Mishra case.
Same order. Where is that order? You have the standard order, sir.
That read appeal number 486 of 2020. Yesterday, item number 46.
Okay. Yesterday's item 46, same order.
Item number 15. It's a state's revision, my lord. The question of law is that case 29 of the revision petition, whether on the facts and in the circumstances of the case, imposition of penalty under subsection 5.
So this tax effect is 2,08,000. Yeah. But that 1,39,000 has been set aside. Same purchase suppression, sir. You've already that Gopal traders have done that. You see, the present revision petition by the department arises from an order dated 30th September 2021 passed by the Orissa Sales Tax Tribunal, partly allowing essay number 70 bracket BAT of 2007-8 filed by the respondent SSC opposite party SSC against an order dated 5th November 2007 of the Assistant Commissioner of Commercial Taxes bracket appeals, Puri range for the period April 2005 to October 2006. Paragraph. The demand against the SSC was raised on the basis of purchase suppression on account of purchase of empty bottles. Full stop. It was factually found that the challans which were recovered from the premises of the appellant relating to Messrs. Jateshwar agencies were not accompanied by sale bills so as to reflect any suppression of sales. Full stop. Therefore, calculation of sales suppression on the basis of delivery challans was not found acceptable either by the first appellate authority or by the tribunal. Paragraph. This being purely a question of fact, the court does not consider any substantial question of law having arising from the impugn order of the tribunal. Stop. The revision petition is accordingly dismissed.
Item number 16.
My lord, this is entry tariff 2J matter. This matter has been fixed to 6th February.
All right. List on 6.
Copy to be submitted.
Item number 17.
17, my lord, states revision, my lord.
Seems like a reverse back.
Question of law is at page 29, my lord. Whether on the facts and circumstances of the case, imposition of penalty is concomitant when the dealer assessee is assessed to tax in the assessment under section 9C of the Odisha Entry Tax Act 1999. Whether on the facts and in the circumstances of the case, the observation of the learned tribunal runs counter to what has been laid down, but my lord has already decided.
So you are there in this, again, same Havells India only.
Notice, ma'am.
All right, notice Mr. Mohanty accepts notice. Let's on 9th August.
Item number 18.
May it please your lordships. Your lordships may kindly grant me 1 week time to rectify the defects.
All right, let's on. Oh, I think I returned that date on some of the matters. All right. List on 1st March, defect be removed in the email. Right.
Published. Your lordship, so item number 19 and 20, I'm appearing on behalf of Mr. S.R. Patnaik. Your lordships, in this matter, Honorable Justice M.S. Raman.
Instead of we have.
Yeah, it is to be put up on, your lordship has fixed on 10th of March.
Same
the
party.
same matter.
Same party.
Same part.
List on 10th March for a bench of which Justice Raman is not. Remember.
That is STRV number?
STRV on 6 and 7.
No,
So
that
the
was
8 and 9.
Yesterday's.
8 and 9.
Along with
STRV number 8 and 9
of 22. All right.
Highly obliged.
Item number 21.
My lords, 21, my lords, Justice Raman was a
Arguing counsel before
All
the
right.
trial.
List before a bench of Justice
Copy to be
Raman
served.
on 17th March.
Item 22.
May I please, your lordship? I will kindly grant 2 weeks time. In the meantime, I will remove the defect, my lord.
All right. 1st March, defects be removed in the meantime.
Obliged.
Item 23.
Oh, list on 17th March before a bench of which Justice Raman is not. Justice Raman is right.
Item 24.
Same.
Item 25.
I play 2 weeks time to remove defects, my lord.
All right. List on 1st March, defects be removed.
Item number 26.
Item number 26 to 29, your lordship may permit to withdraw.
All right. Dismisses withdraw.
Item number 30.
Lordship, the limited prayer, the petitioners are villagers, they are demanding declare their hamlet village revenue village. They file representation before the district magistrate collector.
All right. The petitioner's representation, bracket annexure 6,
my lord,
shall be examined by the collector.
By the collector, opposite part note 2, Lordship.
Baleshwar.
Baleshwar.
And after notice to the petitioners and giving them a hearing, a reasoned order should be passed not later than 1st June 2023.
My lord.
And be communicated to the petitioners within a week thereafter. The court clarifies it as not expressed in the
Supplementary list. Item number 32.
Mr. Behura.
Item 32.
32, no instructions.
No instructions dismissed.
Item number 33.
Your lordships, item number 33 to 37 and 39 are entry tax interest matters, which has been scheduled at 2.
All right. Item 38.
38 infractures.
Infractures dismissed.
Item number 40.
No instruction.
No instructions dismissed.
Item 41.
31, my lords. First appellate order under GST Act is on to challenge, my lords.
So the 10% has been paid.
My lords.
All right.
Copy to be served.
Notice 8 weeks reply. He joined up for the next 8 list on 24th August. Then the IA, since 10% of the demanded tax has been paid, subject to the petitioner paying 20% of the remaining tax, demanded tax. Within 4 weeks, no course of steps will be taken against the petitioner during the pendency of the petition.
42, same, my lords.
Defects be cured in the meanwhile.
Yeah.
The IA is disposed of.
42.
42 the same.
Item number 43.
Your lordships, here the petitioner challenged the order of the first appellate authority in GST Act. But here, your lordships, the order has been summarily rejected. And your lordship, in the similar circumstances, your lordship had passed an order.
The summary rejected, but failure to make pre-deposit.
Yes, your lordship. No, it was for the delay condonation of 30. There was a delay of 30 days. So it was summarily rejected. But your lordship, the petitioner is in no condition to for the payment of money. So your lordship may kindly direct for the 10% payment. 10% has been paid and another 10%.
He will decide, my lord. The first appellate authority will, as statutory. As per the statute, he has to deposit.
He says he's already paid 10%. You paid 10% or
yes, your lordship. 10% has already been paid.
Nowhere he has.
Limit file.
Yeah. No, to same order. 22nd February, I think this date you can change.
This is a different order, my lord.
Huh?
Here notice has been issued.
That's right. Here also we got to issue. Give the returnable date of 11th May. And same interim order.
Highly obliged.
Item 44.
May I please, Your Lordship? Lordship, in this case, the period before Your Lordship is 21-22. A show cause notice was issued to me on 29th July 2022. The show cause notice alleged that I have declared rupees 27 lakhs a mod in my GSTR 1 and I have paid rupees 20 lakhs in my GSTR 3B. Your Lordship may kindly have a glance to Annexure 1, Your Lordship. Lordship may find it at page 20. The show cause notice was issued under section 73(1). Your Lordship may find it from the column for the period 21-22. Tax liability as disclosed under GSTR 1 is 27,94,831 and the liability disclosed in GSTR 3B is 20,34,834. The difference in liability comes to 759,997, Your Lordship. Your Lordship, subsequently, Your Lordship, the facts are as such that I was unable to give a reply because it was all uploaded. It was not in my knowledge. Then an order under adjudication under 73 was passed, Your Lordship. Your Lordship may kindly see at Annexure 2, page 42, the statement of liability that is reflected in the GST portal for the period 21-22.
Yes.
Your Lordship will find it from the first column that the liability as per GSTR 1 is 27 lakhs. Then the second column, liability paid as per GSTR 3B is 30 lakhs, which is paid. And the shortfall stroke excess liability is 2,41,000. That means I've paid in excess, Your Lordship. The figure that Your Lordship found at the show cause was 20 lakhs, that was short payment. Instead, I've paid 30 lakhs, which is in excess, Your Lordship. So on facts and on record, the very allegation in the show cause notice is out and out wrong, Your Lordship. As the matter stood thus, Your Lordship, on 28/12, from my cash ledger, rupees 5 lakhs some odd was debited, and subsequently on 30/12, a bank attachment notice was issued for the balance amount. That is, the entire amount under adjudication order was 8 lakhs some odd. So it was 5 lakhs was taken from my debit ledger and 3 lakhs some odd was asked the branch manager to keep on hold, Your Lordship. So this is how they have recovered when out and out, Your Lordship. I have
in excess.
Yes, Your Lordship. And that problem, Your Lordship, the paid in excess has been rectified. Actually, the liability is 30 lakhs. So in my annual return, GSTR 9, Your Lordship will find it at page 28. Sorry, page 34. I have rectified the same and the liability is actually 30 lakhs amount instead of 27 as reflected in my GSTR 1. So I have made the entire payment. So the allegation that there is short payment is wrong out and out. And
no, otherwise is this order an appealable one?
Yes, Your Lordship.
Then why don't you file that appeal?
I have paid the entire money, Your Lordship.
So that will point out in the appeal.
But for that, Your Lordship, I have to pay 10% again to make that appeal sufficient, Your Lordship. I have skipped that bus. That is an admitted fact, Your Lordship. Now I have come, since it came to my knowledge only upon my cash debit being debited as well as the bank account attachment. Your Lordship will find it at page.
No, since
40.
your attachment is there, we'll
Yes.
say they don't insist on a pre-deposit because the attachment is there. I think that's the.
That is an additional liability, Your Lordship.
How do you overcome delay in filing the appeal? That's another problem you have. Where did you
filed
get
writ application in January only.
Yes.
So
Yes.
by then 107 entire period goes.
Yes, Your Lordship.
So now we relegate you to avail the appellate remedy. How will you overcome that?
That is why I am before Your Lordship.
Yes, what do you say?
Well, the Suku's notice dated 31st/8/2022.
No, that attachment seems to be unjustified. No? They paid in excess.
That has to be verified, my lord.
All right, you just say notice. He accepts notice. Reply within 8 weeks, rejoinder for the next date. In the IA, you say list on 10th May. That IA, you say, counsel for the petitioner points out that the petitioner has in fact paid excess amount of tax as explained in the petition. And nevertheless, not only a sum of rupees $5 lakhs and odd, is it?
Yes, Your Lordship.
Where do you get
Page 50 and 49. Both added together is state tax and central tax. And at page 52 is the attachment issued to the bank.
a sum of over rupees 5 lakhs recovered already from the accounts of the petitioner, but
By debiting the
account
cash
or-
ledger.
by debiting the electronic cash ledger.
Yes, Your Lordship.
But the further sum of rupees 325,444 lying in the bank account with Canara Bank stands attached. Paragraph. In that view of the matter, it is directed that till the next date of hearing, no further coercive steps shall be taken against the petitioner. All right.
Your Lordship, that will amount to me paying the entire tax as well as this 8 lakhs amount being also withheld. Because my cash
We'll have
ledger.
to ask them to file a reply. We can't
Then
allow it today.
Your Lordship, I kindly fix a short date, Your Lordship.
10th
Your
May.
Lordship, the petitioner has availed QRMP scheme, that is the quarterly monthly payment scheme for consolidated payment. So he had debited his cash ledger for the payment towards that, which is to be deducted on 24th January. So they debited the money prior to that date. And now the petitioner cannot also deposit for the QRMP scheme. The due date was there.
Then, my lord, let him appear before the appellate authority and you will decide all those things.
No, but the appeal will be time barred, sir. The whole problem is that it can only be 13th April. Let's see. List on 13th April. All right. 13th April.
Obliged, my lord.
Item number 45.
Memo is taken on record. Dismisses withdrawn.
Item 46.
46 is a refund of application fee. It is covered by Lordship's order. I have enclosed Annexure 3. No changes will be required.
All right. Same order.
Item 47. Item number 47.
None appears, so the appellant dismissed. Not prosecution.
Item number 48.
May I please, Your Lords?
Yes.
As per note, my lord, Your Lordship give some time to file the impugned judgment, certified copy of the impugned judgment, my lord.
All right. List on. (21st March), defects be cured in the meanwhile.
Item number 49. Item 49.
49 I am for the respondent.
All right. None appears.
Item number 50, my lord. 50.
1 minute, sir. We are in 49.
Oh, 49.
49.
None appears for the appellant. Dismissed for non-prosecution.
Item number 50.
My lord, item 50, 51 and 54, Sarat Parida case, my lord. I'm passing the copy. And 52 is also Sarat Parida, but here respondent has already appeared. I have also submitted that copy of this. This can be disposed of, my lord. 52 can be disposed of, my lord. The respondent has already appeared, my lord.
So 52, you pass this order. Only the dates have to change. This is in 52.
52, this and 50, 51 and 54 I have passed on that.
Same or 50, 51. All right.
Obligement.
Item 53.
I have given the copy, my lord. This is regarding regularization of DLR employees. On first day disposal, I lordship has page 15 is the input order.
25th April.
That has been fixed to February
25th April.
25th April 2023.
All right. Say what was the order, the petition number.
Item number 55.
I may please your lordship. Lordship, this is a Westland lease case matter. Lordship is on 2nd January.
That is Narottam Rathar. Both 55 and 56.
56, 55 and 56.
All right.
In 55 and 56. Item number 57.
So, I am appearing in this case in sub-item, in WPC number 32826, 32827 and 32831. Yes, I am appearing for some entrepreneurs. But the main matter related to OTET, Mr. Sivasankar Mishra is appearing.
Malats, on behalf of Mr. Sivasankar Mishra, I pay for Passover to be taken up at the end of the.
No, my lord, let me tell you, lordship, what this case is. If your lordships will recollect, my lord, just hand over that number. Your lordships had passed an order on 24th of August, requiring them to go and appear before the secretary. And then he will take a decision. I'll tell you what it is. There was a policy. And against that policy, one matter went to the Honorable Supreme Court. That Supreme Court order.
Don't give it in piecemeal. I think better let it be taken up after 2 o'clock or after the matter fixed by your lordship. Your lordship have fixed up one matter 2 o'clock. That batch entry tax matters. After that, this will be taken up.
Can we do it on Monday? Because it can be disposed of.
It can be disposed of, yes. Monday I have no other. No. Yes, today at the end of the day.
But now there is a Government of India scheme. And under that scheme, everything is regulated. That is what that is what has been decided by the government, my lords. They were running 27 centers which stand protected till disposal of the writ petition.
In fact, that protection is not available. As my friend says,
for the 27 is available.
The judgment of the Honorable Apex Court said to protect the notes.
Yes.
Despite of the judgment,
27 are protected.
No, I am one among them and I am asked to remove.
Then you file an affidavit, we'll reply.
That is what I have given. This reproduction is affidavit also. So that is why I say let it be taken out so that entire matter can be thrust out. We also rely upon Honorable Apex Court decision. And we have taken loan, established notes.
This court is perused. The order passed by the Supreme Court of India. This was already shown to us previously.
Yes, it was shown to your lordship.
That's what.
That is why your lordship said you go there, whatever the government will decide because it's a
Correct,
matter of
correct.
policy.
And what has the government has taken a decision?
The government has taken a decision saying that since there is the e-Sanjeevani scheme of the government of India now, where all these facilities are provided for, under that scheme, everything is covered. That letter also I have given to your lordship.
Oh.
And it is free of cost. If your lordship sees, my lord, that is page 1 to 6 of the memo I have given.
If your lordship will kindly remember, prior to approaching in these petitions, I have approached lordships earlier also. Your lordship permitted me to first file representations. Then, depending upon the outcome, you can reapproach. I have approached minors. Representation copies are being annexed here. And those are not considered. And now they say that no reimbursement of expenses, nothing you vacate. But so many are there. All are prejudiced now. Your lordship have to examine minors. That is why I say, at the end of the board, or my friend suggests Monday also, I have no objection. So that Mr. Mishra also can, because he appearing for voted, his interest is.
All right.
Minors.
A passover is sought on behalf of Mr. Shivashankar Mishra, learned counsel for the petitioner, which is not convenient to the learned advocate general appearing for the state of Orissa. List on. Third May.
Lordship, please.
Deeply.
All
right. Deeply.
Oh, the connected May 12659 of 2015 memos taken on record dismissed as infructuous.
Item number 58. I guess Justice Rahman may recuse himself.
All right. So list on 24th March before a bench of which Justice Rahman is not.
At that time, he was a vibrating counsel. The other day, I told him that Chief Justice S. Muralidhar is an epitome of knowledge.
No, please.
And you learn from him.
No, mutual.
That is a...
All right.
Supplementary list item number 59. Item 59.
No instruction.
No questions dismissed. All right.
Item number 60.
My lord, kindly see, my lord, that last order passed on 29/4/2019. This is a PIL, my lord, that 14 rooms, Pakka rooms, have been constructed illegally inside a school premises. And DO has given the report that this is illegal construction. This is school's land, but some influential person, I'll say, my lord, the local MLA, constructing all these things by his henchmen. That's why all district officials are afraid of, and they didn't
take action.
They didn't protest. That's why, my lord, this PIL is filed. And this honorable court stated, in view of the matter, Collector cum District Magistrate Khordha, OP number 2 is directed to file reply by the next date. Opposite parties are directed to stop the illegal and unauthorized construction as alleged in this petition immediately. My lord, what collector
just
has...
come to this counter filed by opposite party number 2. Have you seen that? 16/12/2019.
A counter
of opposite party number 2.
Samal, Tahsildar. On behalf of the collector, he has filed.
He has not served me the copy.
Copy has not been served.
No, collector himself has filed, and then
I have the counter of Vrindavan Satpathy, the DO.
No, Sitanshu Kumar Raut. Collector Khordha has filed.
Yes, yes.
Let your copy solve. I have the Vrindavan Satpathy filed, that counter, I have that.
That is the counter filed by the DO, my lord.
DO counter is with me, which is clear that they have illegally constructing and it is not. But what is the collector has filed, that is, then let me solve a copy. And to the counter of the DO, I have also filed the rejoinder reply. But I have, government has filed the counter but not solved the copy, I think. I have no copy in my brief.
2 to 4. So Sanskrit school itself has been closed now. That's what they say. You say counter affidavits have been filed, separate counter affidavits have been filed.
There's a school, my lord. That's not a commercial place. That's
No, that school itself is closed, madam.
My
That's
lord.
what they say. Separate counter affidavits have been filed by opposite parties on behalf of opposite parties 2 to 4 on 21st September 2019 by the Tehsildar for the semicolon on 20th September 2019 by the inspector in charge Model Police Station Khurda, and on 16th December 2019 by the collector and district magistrate Khurda. Copies of these counter affidavits be served on concept that the petitioner was permitted to respond thereto before the next date. 11th May.
My lord.
My lord, I will serve copy of all these affidavits.
Yes.
It is already served. I will serve again. I will serve.
It is your general.
Item number 61.
Your general.
61.
Item 61. I'm swearing for the intervener, my lord, on behalf of Mr. Kunde. I pray for some time.
No, 1 minute. Who's for the petitioner?
Yes, your lordship. Lordship, here the petitioners are assailed the impugned order dated 28/2020 passed by the OP number 2 collector Sundargarh in not recording a water reservoir by virtue of the water reservoir in the name of the government of Odisha by virtue of the amendment section 5B of the Orissa Merged Territories Village Offices Abolition Amendment Act 1976. Your lordship, kindly have a glance to page 60, the impugned order. Lordship 5B says, your lordship, first of all, your lordship may kindly have a glance to the impugned order at page 60 under Annex 6. This is regarding the implementation of the Orissa Merged Territories Village Offices Abolition Act 1976. Plot number 381, an area of 7 acre 94 decimal under Khata number 130, plot number 382 with an area of 44 decimal under Khata 151 of the village Aula Bahal under the Leftripada Tahsil. Starts recorded in the name of Rohit, status in the name of Sudarshan Patel, son of Parmanand Patel. Whereas the plot number 381 is a Munda. Munda means pond water reservoir. Munda is locally named as Munda. That is called a reservoir pond. Kisam, plot number 381 is a Adi Kisam, that is the embankment of the pond. Originally, these two plots formed a part of Bhogra lands. It's a Bhogra lands, which was settled in favor of the recorded tenant. In this connection, it is pertinent to mention here that prior to coming into force of Orissa Merged Territory Village Officers Abolition Act,
You got a copy of the counter affidavit?
Yes, your lordship.
You don't wish to file a rejoinder?
Lordship, since I have all the things have been dealt with in the writ petition, therefore the rejoinder is not absolutely necessary.
But I have denied everything, whatever you have alleged.
Denied. Lordship, I have already dealt with in the writ petition everything.
No, you have to deal with the reply then. If you don't deal with the reply, we'll assume the reply is correct.
All right, I have given a reply.
There is an intervention application.
They have also filed a reply, separate reply. Separate counter affidavits have been filed by opposite parties 2, 3, and 4 on 23rd August 2021 and by the interveners on 5th July 2022.
5th July?
5th July 2022, the interveners are filed.
Yes, ma'am.
You've got a copy of that?
Yes, I've already received a copy.
Rejoinder to both affidavits, if any, be filed by the petitioners before the next date. (22nd August).
2nd of
22nd August.
Item 62.
In item 62, I'm in VC, my lord.
Yes.
This is the case with regard to the espionage, which took place at the ITR at Chandipur, Integrated Test Range Center, my lord. As per the last order, the state government and as well as the central government, they were to file a status report. I believe they have not yet filed. So we do not know exactly what is the present status, my lord.
Yes, Mr. Padi. Mr. Bera. Yes.
My lord, sir. So for a status report, we have got the instructions, my lord, and they have given us the report that how we have supported the investigation by the state agency. My lord, we'll file the affidavit within 2 days, my lords.
All right. Mr. Bera, appearing on behalf of the Union of India,
my lord,
states that the affidavit indicating the current status will be filed within 2 weeks. Rejoinder that if any be filed for the next date.
The state was also supposed to file an affidavit, my lord, regarding the status report.
Yes.
The state government, my lord.
Who's for
Yes, my lord.
This that test range
will file affidavit.
Mr. Manthi, learned AG state will also file its affidavit within 2 weeks.
My lord, the repetition copy has not been served on us, the state.
What time number of occasions it was already listed. I will serve another copy, my lord.
No, it is not listed. It is
All
not
right.
in there.
As far as
Otherwise, I would
state
not
government
have-
is concerned, a copy of the repetition be served on Mr. Manthi today itself.
My lord.
To enable them to file an affidavit within 4 weeks.
But this is the
Rejoined
fourth or
to
fifth
both
date of
affidavits to
listing.
be filed before the next date. List on 10th August.
Item number 63. I have responded to the press affidavit filed by friend today by filing a rejoinder, my lords. So I will take on record, but I am sorry because I wanted that matter should have been.
No, but I undertake not to file any more affidavit, Your Lordship. But the sorry rejoinder has been filed, Your Lordship, under compelling circumstances, Your Lordship, because in this case, the constitutional validity has been challenged. But in my counter, original counter, Your Lordship, since only assessment order has been challenged, so on that reason, counter has been filed. So in sorry rejoinder, I have to counter the so far as the validity is concerned, Your Lordship. Only under compelling circumstances, I filed that.
Your Lordship, while admitting the matter relegated so far other issues are concerned, without prejudice, I have been paying money. The whole difficulty, my Lordship, kindly bear in mind, this is a government of India undertaking. But so far as SKO, kerosene oil, my Lordship knows it's a poor man's fuel. I purchase at, suppose 100 rupees, I have to sell at 70 rupees or 50 rupees. Now, input tax which I pay on 100 rupees, to the extent it becomes surplus over and above the output tax payable because of the lower price, they say this will be waived. But in addition to law, this is insult, adding insult to injury. Bearing loss of selling at lower price with the policy of the government to poor people, and again, they take away my. That is why section 28A, which have come by amendment, I have challenged Your Lordship. I am also pleased to admit this. My humble prayer is, my lords, I know where I will be if Your Lordship will adjourn. But keeping, I am scared of that only. So my lords may kindly look into this and have a subtle. This can be
also this issue has already been decided by Honorable Supreme Court.
Then
it is that Madras High Court judgment.
If that is so,
Your Lordship, that has been decided, Your Lordship. Honorable section 19 subsection 20 of Tamil Nadu Value Added Tax Act, Your Lordship, is identical to this 20 subsection 8A. So, Honorable Madras High Court has intervirus that provision, and Honorable Supreme Court has confirmed, Your Lordship. So, Your Lordship, that is
share with me a copy of the judgment so that we can address.
Employment company in my county, in my.
You share me a copy of the judgment. At an audited matter can be disposed of. I will examine and matter can be disposed of. If that is so, I don't think our provision is similar to that.
Similar.
And tax may not be similar.
Identical.
That is a different situation.
Identical. Honorable Madras High Court judgment as well as Honorable Supreme Court judgment, both I have.
JM and Company. Correct.
Your Lordship, my Honorable Madras High Court judgment, Your Lordship may kindly turn to page para 17. Whether the amendment by inserting section 1920 of Tamil Nadu value-added tax, reversing the amount of the input tax credit over and above the output tax of those credit, is not within the legislative competency of the state legislature under entry 54 of the state list and ultra vires of the. This is the question of law, Your Lordship. So far as the retrospectivity here, that is not the question. Now, Your Lordship, section 1920, Your Lordship may kindly turn to page 11. Paragraph 28, the provision is there. Subsection 20. Section 19 starts at page 10. Subsection 20. Notwithstanding anything contained in this section where any registered dealer has sold goods at a price lesser than the price of the goods purchased by him, the amount of the input tax credit over and above the output tax of those goods shall be reversed. Now, Your Lordship may kindly turn to section 20, subsection 8A. How this is parametrically identical, Your Lordship, of the Odisha Value-Added Tax Act.
No, have you studied these judgments?
No, I have not examined. That is why I say, let me examine.
All right. A reply has been filed with the petition in reply to this letter rejoinder filed by the opposite parties. It is made clear that there will be no further affidavits as far as the present petition is concerned. Paragraph. Learned Counsel for the state relies on the judgment of the Madras High Court in JM and Company versus Assistant Commissioner bracket CT 2014 1 MLJ 157, which has been upheld by the Supreme Court of India in JM and Company versus Assistant Commissioner 2016 SC 4443, and submits that the said decisions cover issue in arising in the present petition against the petitioner. Mr. Jagabandhu Rahul and senior counsel appearing for the petitioner seeks some time to study the above judgments. At his request, list on 9th May.
Item 64. I may be pardoned, my lords. The sub-item along with this 63, STRB number 94 of 2014. That issue is little different, my lords, not with the issue with what my learned senior was arguing.
The same sale price has been reduced.
There is a category.
Whatever the reason, Your Lordship, whatever the reason, Your Lordship, the provision is very clear. Whatever the reason,
They still have to pay on that.
Your Lordship.
So list along with
the same here, Your Lordship, the constitutional validity has not been challenged, but the provision itself has applied by the tribunal by the forum below.
Passed on to the yes.
Your Lordship, interim order to continue.
Interim order to continue.
Okay.
Item number 64.
64 to 68, my lord. 60 entry tax matter.
2 o'clock.
Yes, my lord.
So item 65. Plus, my stand in this case is completely different. The reason being, my lords, unlike other cases, here levy of interest under section 7.5 arises from out of audit conducted by the audit visit report, my lord. So based on audit visit report, audit assessment is made. That's my only emphatic submission for lordship is, which I have awarded the petition is.
Sure.
7.5 is a statutory interest, and that presupposes fulfillment of certain conditions, my lords. And condition is, if without any sufficient cause, a dealer fails to pay the amount as per the return due, these are the catching points. If there is sufficient cause, 7.5 may not be attracted. Whereas if the due must be arising out of the return mirrors, amount found due from the return mirrors. If nothing is due as per return, then it cannot be recoverable. I mean, no interest liability can be there under section 7.5. And your lordship will find, so far as the stay interim orders are concerned, my friend is referring the other day, referring to other. My case interim order is passed with some different wording mirrors. I have been by this honorable court when I was for lordship mirrors. This honorable court said that you are not required to pay the tax as per return. You file an affidavit in the future return that you will be going to file. That order was passed in 2011, and the period involved is after 2011 years. So I went on filing return as per your lordship direction, and I am required to pay 50%. That is what I complied with, my lords. I filed an affidavit as per your lordship direction, my lords, to comply with the interim order, my lords. And going to Supreme Court, after that, Tata Steel late judgment on import, my lords, by this honorable court. I went for the apex court, my lords. Honorable apex court in my case, my lords, unlike other cases where honorable apex court while passing interim order said, if you succeed, you will be getting interest. If you lose, those are not there in my case, my lords. No, just let me. So therefore, as per honorable apex court direction, my lords, I went on complying. So therefore, one thing my lords may kindly keep in mind, whether anything is found due as per return, my lords, answer is no, my lords. And whether there is sufficient cause, apparently there cannot be more sufficient cause than the interim order passed by the honorable apex court and this honorable court. So this being so, my emphatic submission is that 7.5 could not have been invoked for levy of interest. This is one. Secondly, this being audit assessment, my lords have decided in Bhushan Steel's case, unless it emanates from audit report, this cannot form subject matter of audit assessment. But the recourse is otherwise. One can take care of under section 10, the authority is always there, power is always there. But section 9C assessment cannot deal with any matter which are not there in the audit visit report, my lords. That is what your lordship said in Bhushan Steel's case, my lords. So, my lords, my humble submission would be that whether or not in all those cases, my lords, that is a batch is there at 2 p.m. your lordship have fixed. But my case is, my lords, whether 7.5, which constitutes the crux of this audit assessment, and your lordship have admitted the matter to my lords, and one more matter is also there. Your lordship said that will also be taken care of by the time of hearing the petition. Your lordship have it clear in that regarding levy of tax on steel structurals. So therefore, my humble submission 7.5, only your lordship will decide whether under these circumstances, and particularly when the assessment is made originating from audit visit report, whether 7.5 does at all attract. And so far as the language of 7.5 is concerned, whether interest can at all benefit. When I comply bona fidely, as per your lordship direction and direction of honorable apex court. And till today, it's a matter of 2018, my lords have issued, till today, no reply, nothing, my lords.
Your lordship, in all those cases, that is the main ground regarding sufficient cause as per section 7.5, your lordship. So it will be premature to argue just now this matter, your lordship, so far as that reasonable cause, whether this is the sufficient. If my lord and senior doesn't want to be in a part in that group, your lordship, let it be adjourned to some other day.
No, I don't think
consequentially, but that is the main issue, your lordship, whether that is a sufficient ground or not. In all those cases, the basic argument, the main argument is that, your lordship, whether it is whether 7.5, whether the ingredient of 7.5 fulfills or not, your lordship, that is the main argument in that group. Your lordship, my lord and senior will argue in those on behalf of the state in all those cases, your lordship. So it will be premature on my part to argue, to open my argument on that issue, your lordship.
So those arise of E24.
And so far as this is assessment order, your lordship may kindly turn to the prayer. Here the assessment order has been quashed. And so far as the audit report is concerned, here in the first page of the assessment order, it is pursuant to the audit visit report, your lordship. So my lord and senior will allege that without any audit visit report, this assessment has been completed. Then I have to call for the record because I don't say so. I am saying on the face of the assessment order itself.
He says it has gone beyond the audit visit report. He says what is pointed out in the
that beyond I can argue, your lordship, that Bhushan judgment is not applicable. Your lordship, that Bhushan judgment, your lordship, I may be permitted to produce that judgment. In that judgment, what happened, your lordship? In that judgment, so far as the CST Act assessment has been concerned, a fraud case report has been adjudicated in course of assessment, your lordship. So this honorable court has stated in that case that no, if any other report cannot be adjudicated so far as the audit assessment.
Balaji Tobacco is staring at you. Subsequent judgment, correct. Balaji Tobacco, which has followed Bhushan and laid down that you cannot traverse beyond the.
Your lordship, I may be wrong, your lordship.
Challenge that. You are not challenged that.
Your lordship.
Both the cases, you are not challenged.
Your lordship, so far as the travel beyond what I understand, your lordship, audit with so far as the books of accounts related, only the assessment is to be done only basing on the books of accounts so far as the audit is concerned. No further report, your lordship, cannot be adjudicated, your lordship. Any enforcement report, any fraud case report, those cannot be adjudicated so far as the audit assessment is concerned. Those can be separately adjudicated in a separate proceeding, your lordship. And all the judgments, your lordship, so far as the Bhushan case is concerned, all the judgments specifically said so, your lordship. So this case may be adjourned to some other day, Your Lordship. So far as the interest is concerned, it is consequence to all those cases, Your Lordship, all that batch, Your Lordship, and so far as that other issue, Your Lordship, I may
let them file counter,
my lord, item 67, 68, my lord. This entry tax matter where I had come before your lordship in 1750 of 2018, and the matter was sent back to the commissioner. I was directed to file a revision before the commissioner. The commissioner has now passed the order, firstly saying that it is a res judicata. Your lordship had decided, and I have filed that challenge. No counter has been filed. And second, he says that he is governed by the body, higher body, who decides that law would be decided in this manner. Therefore, I'm deciding this. And also, third thing is, he's charging interest on a large amount of refund which have been adjusted here. And fourth is that your lordship has decided in the case of Bajaj Auto that the default will be only after the judgment of the Supreme Court. He also doesn't take into consideration. He said that E24 is issued without previous entry, issuing E22 and 23, which your lordship has.
Mr. Monty, let's complete this, what Mr. Sahu was mentioning, and then we come to that. Item 65, you say, it is seen that despite notice having been issued in this petition way back,
March 2018.
20th March 2018. Till date, no reply has been filed.
4 weeks time
by the department. Full stop. Last opportunity is granted to the department to file a reply within 8 weeks, rejoined up for the next date. The interim model will continue anyway. There's some installment.
I have paid the tax. So
there's no question.
But the interest minutes are yes. They may now.
I have filed a modification application.
No, that modification now, in view of that, you will file counter. So
no, your lordship,
no coercive action.
Your lordship, no coercive action has been.
Already your lordship passed interim.
No coercive. Your lordship
on 23/18.
Your lordship was directed to pay the tax and interest. Your lordship, so far as the interest, your lordship may similar direction in those batch of the cases.
No, this is different.
From the date of order of Honorable Supreme Court, let him pay the interest. Your lordship.
This is different.
Your lordship, the previous interest, your lordship, subject to your lordship's adjudication, your lordship. But so far as that, your lordship, my modification IA is pending, your lordship. That IA number 17481.
Not filed in this case. No, not filed in this case. This is different. Your lordship have deliberately not consciously passed this order granting me interim direction, and they have not responded till today. So that order may kindly continue, sir.
There is no case for vacation of
correct, sir.
Stay order.
No,
I'm sorry.
Not in this case, sir.
All right. Interim order to continue list.
Yes, this matter may kindly be taken up along with 3529 of 2018, in which same issues are involved.
All right. Along with 3529 of 2018.
Minus. This is there in the other batch that may be dealing, and this will be
16th May.
Part of the first page limited.
16th May.
Minus.
All right.
Obliged.
Item 66 and
67. Challenge 75. And secondly, my lords,
item 68.
This matter has been similar matter. Section was 271 1A of the Income Tax Act. There, their lordship had held that because of that 271 1A was completely taken away. Their lordship have held that the burden is on the income tax officer first, because the language is not failure to submit return, but language is without sufficient cause, failure to submit return. So therefore, I do not know whether they have filed a counter or not, but this matter may come up along with Mr. Sahu's matter. I have given a detailed note also.
Yes, here again counter had to be filed.
Your Lordship, here the same against the revision of commissioner has been filed. Your Lordship, as like as that Sri Bharat Motors, Your Lordship.
No,
Same E24, same E24, same revision, same levy of interest, Your Lordship, all the so Your Lordship, that it can be tagged with those petitions because it is consequential.
Same issue,
Same
issue as what we're taking up at 2 p.m. On payment of interest on the
My lord, I have paid the full tax.
entry tax, yes.
I have
No,
paid
interest, sir, the question of interest.
Interest, my lord, if this adjustment is given, I will not be paying any interest. My lord, substantial money, 1 crore and odd money was with the department, which they have adjusted in the paying this. So they want also to interest on this.
Your Lordship, that is a separate issue. Whether levy is justified, if levy is justified, then that can be adjusted, Your Lordship. Your Lordship, that is the consequence.
You are not adjusting. That's why I have come here. I had come in 1975, 17 to the 15 of 2018. Your Lordship said that you go in a revision to the commissioner so that he will decide and look into it. The commissioner said that it is res judicata. Your Lordship upheld his officer's finding at res judicata.
But either way, sir, the question really now is that why can't it be taken along with the batch?
No, I have no objection. I've given
let's
the
take
note.
it with the batch.
I have given the note and everything. I have given the note edited note of
So 2 o'clock, sir. 2 o'clock. All right.
Item 69.
66, my lord. 66, 67. And 66,
67, 2
66, 67 and 77. 2 o'clock.
80 also, my lord. 80 also.
Okay.
Item 69.
Mailers, I pray 2 weeks time.
All right.
This is GST. I'm not able to GST form 01, 02, 03.
Okay. Rejoinder be filed before the next date.
There is, in one case, there is an interim order. The other case not there. I think
wherever the interim orders are there, continue.
Yes.
Oblige. 22nd August.
22nd of
August.
August.
All right.
In peace.
Item,
peace.
Yes.
Item number 70.
Today is a great day, my lord. The High Courts have opened.
Yes. Right. Tomorrow.
But here, I have challenged the order of the collector under Annexure 14, confiscating my vehicle, my lord.
Right.
It's not appellable. I'm not liberty may be granted to file appeal before the commissioner.
Counsel, the petitioner seeks leave to withdraw the present writ petition with liberty to file an appeal as provided in law. If such appeal is filed not later than 3rd April, accompanied by an application for condition of delay explaining the delay on account of the pendency of the present petition, taken into account by the appellate authority. If such appeal is filed, that seized truck is still seized.
Yes, my lord.
All right.
Lordship is grant some.
Within the time stipulated, then till such time an interim order is passed and the application to be filed along with the appeal. The interim order
is there.
Passed with this court on 25th August 2022 will continue. The originals be returned subject to be substituted. That is for.
There is
There's no original, is it? All right. You remove that claim. The petition is disposed of. All right.
Item number 71.
Virtual mode.
Yes.
Here is the first appeal order has been challenged and I have deposited as 30% of the tax. So department has to file the counter.
4 is time.
All right. Reply be filed within 4 weeks to order for the next date.
My lord, we are appearing for, I have issues to appear for OP 8 and 9, my lord. We'll be filing the counter.
All right.
So I'm appearing in the second sub-item.
So interim order to continue.
Yes. Same order, the second one.
Interim order to continue.
Interim order.
My lord, I'm appearing for OP number 7 in item 1.
All right. 24th August.
72.
Please. Last occasion, your lordship has directed the opposite party to take an instructions of the non-granting of a refund since pending 2021, November 21, and they have issued my refund order in May 2022. This was in view of the direct tax Vivad se Biswas scheme. I had opted that scheme, and it was ordered that there is an excess payment. In Annexure 1A and 1B, November 2020, 10th November 2021.
Anyway, they have to file a reply, sir.
Till that, no reply.
Reply is not been received from CPC, Bangalore. It will take some time.
Final opportunity is granted. The opposite parties to file the replies within 8 weeks, rejoined up with the next date.
Your Lordship, pardon me, this
28th August.
second item is item number 71, the interim order to continue.
Yeah. Interim order both. Yeah. Both.
Obliged.
Right.
There is a refund, this a short date.
No, it's okay. Yes.
Item number 73.
73, my lord. Today we are filing the counter, my lord.
All right. Council, the department states the reply is being filed today, rejoined for the next date. Interim order to continue.
Interim order to continue.
List on 29th August.
Item number 74.
May it please the lordships. This has to be allowed, my lords, for non-traversal. The draft assessment order already covered by your lordship judgment.
144.
Since long, my lords, no counter affidavit has been filed. And today I am grateful Mr. Chimanka was here.
Yes.
Yes, sorry. Sometimes you appear प्रकट हुए आप दाहिने तरफ फिर बाएं तरफ. But this has to what?
62 Annexure 2.
Yes.
So cause notice is the proposed variations to that. It is the draft assessment order.
Arey Baba, where is your draft assessment order? It has to be served along with, you read clause 23.
Show cause notice is not draft assessment order, sir.
Yes. Draft assessment order. It has to be allowed, my lords. I am giving your lordship's own judgment. That is in Sivasya Swami. I would have copied.
All right.
Yes, I am giving my lords.
All right.
आपको कई थोड़े दिया है? No. Please copy. Amora, what did you? दिया इतला. Last time I have filed, man. Yeah, yes. Last time I have given compilation.
9 judgments.
Yes. The first one, where your lordship, day before yesterday, I was arguing a matter before lordship.
Yes,
I pointed out that.
Srivatsa Kumar Swine.
Yes.
It's here.
Yes. Para 5. It is observed that in the present case, the impugned assessment order was passed without communicating to the petitioner any draft order of assessment.
Right.
And this being the assessment year 15-16, they are bound because 144B was amended only on 142022, where they removed this draft assessment order. Now this is covered.
All right. On 1st November 2022, the following order was passed in the present petition. Paragraph. Till date, no reply has been filed by the department. Paragraph. There is therefore no denial of the fact that no draft assessment order as required by Section 144 capital B of the Income Tax Act 1961 has been issued
2.4 I have stated
to the SS in the present case. Full stop. It must be noticed here that the assessment order dated 26 September 2022, challenged the present petition, has been passed for assessment year bracket A1 2020-21, and it has resulted in the consequential demand notice bracket annexure -1 oblique capital A paragraph. The show cause notice receiving it was issued on 2nd September 2022, not accompanied by the draft assessment order as mandated under Section 144 capital B of the Act. Full stop. 144 capital B bracket Roman small 14 bracket of the Act. Paragraph. The issues no longer res integra as far as this court is concerned. With a series of judgments it has been held that the above provision, which was inserted with effect from 1st April 2021, has to be mandatorily complied with. Stop. A sampling of such orders is the order dated 1st October 2021 in Writ Petition Civil 279 of 2021, bracket, Sribasta Kumar Swine versus Union of India, bracket. Orders dated 11th July and 27th October 2022 in Writ Petition Civil 14008 of 2022, bracket, Shamata Foundation versus Income Tax Officer. And the judgment of the
Gujarat High Court,
Gujarat High Court in Enviro Control Private Limited versus National E-Assessment Center, bracket, Special Civil Application number 7370 of 2021, bracket, Gujarat. And the judgment dated 30th September 2022 of the Madras High Court. Yes. In Writ Petition Civil 16373 of 2022, bracket, PT Lee Chengalvaraya Nayakar Trust, Chennai versus Income Tax Officer. Paragraph. In that view of the matter, the impugned assessment order and the consequential demand notice, bracket, Annexure 1 and 1 capital A, are hereby quashed. This will, however, not prevent the department from proceeding in accordance with law hereafter. The petition is disposed of.
I'll pray for AFR, my lords.
How many, sir? All those were AFR, I think, already.
One addition, my lords. Because Mr. Chimanke is appearing, he's very anxious to get his voucher for the bill.
All right.
AFR, my lords.
Okay. Item 75.
75 is regarding to short supply of country spirit. I have corrected the demand notice date and annexure.
Same order. All right. Same orders.
76.
76, not pressed.
Not pressed. Dismisses.
Item number 78.
Item number 78 and for the appellant. On behalf of Mr. U.K. Samuel, I pray let it come any other day. I have to file a short reply. My non-friend is appearing. I have also requested him to accommodate.
Appearing for appeal number 5.
Yes, file a.
This is all appeal, sir. Where's the question of counter joint or not?
Any other day, you'll also make it up. As per convention.
Petition is pending. This
plus 3 Stream College to the ADM Kyonjar. There's no interim order here, no?
No, whereas this writ appeal is against an interim order.
Sorry?
This writ appeal was against an interim order. The writ petition is pending.
It's still pending, is it?
Yes, ma'am.
Oh. But there's no stay.
No,
so which means it's been handed over to the ADM.
It was handed over to the ADM. Thereafter, the ADM appointed respondent number 5 here, OP number 5, as the principal.
And he's continuing.
And then there is an inter se seniority dispute between OP number 5 and OP number 6.
That's okay. That's not part of this writ appeal.
So as far as the appellant is concerned, his contention has been negative, by the single judge, which is the impugned.
That is, he wanted to continue as principal, is it?
Please,
So then what remains, sir? There's no stay of the order. 2018, 5 years, he's been continuing as principal in charge for 5 years.
Continuing. So you'll also take up any day.
Petition the writ petition is pending.
Since there's no stay, you can only permit you to expedite the writ petition.
And dispose this.
That's right. You say the present writ appeal itself has directed.
May I say one thing? You'll also take up tomorrow also. I am for only any day tomorrow. And next week, any day, as per convenience of Lordship, my lords. For final disposal.
Counsel for the appellant is stated in some personal difficulty. List on 29th August.
Published.
Item number 79.
The appellants, my lord, are two sweepers in Orissa State Road Transport Corporation, my lord. They are continuing under daily basis since 2000, my lord. And they were called to appear after regular vacancy arose, my lord. They were called to appear an interview. They succeeded in interview. After successful, my lord, interview, they were appointed. Interview was made for regular basis, my lord. They have been appointed on a contractual basis. Till today, they are not regularized. Sweepers, my lord.
Is there a scheme for regularization? Unless there is a scheme, we can't just order that, sir.
Well, the interview was made, but they directed to appear the interview for regular appointment, my lord. They succeeded in the regular.
No,
There
but
is no
unless
scheme
there is
for-
a scheme, sir, you can't simply claim regularization.
There is no scheme for regularization.
Then?
There is no scheme. Regular vacancies are available, my lord.
Right.
We appear the interview for regular appointment, my lord. We succeeded in the interview. We succeeded in the interview for regular appointment. But the appointment made on a contractual basis.
No. Sometimes contractual appointments also, they call for interview and all that.
Contractual appointment, now it is abolished in the state, my lord. It is now abolished. But what they did, my lord, they conducted the interview for regular appointment, my lord, after regular vacancies. There is no provision for contractual appointment. They conducted the interview for regular appointment.
No, your letter of appointment would have said you're being appointed on contractual basis. Your letter of appointment.
Yes, ma'am. That I
it
challenge.
does say it's on contractual basis.
That I challenge, ma'am. That I challenge.
No, not on contractual. It says part-time.
No, part-time. Initially, it was part-time, my lord. After I was succeeded in
the contractual. Then it says contractual. Correct.
Contractual, my lord. How? But when I appear the interview for regular appointment.
No, but under the government's policy, after 6 years of contractual appointment.
Yes,
corporation, man. It is a corporation.
No.
You have not
now, Group D, Group C, and Group A, B, I think. 2013 rules have come that after 6 years of contractual appointment, they will be formally given regular.
This is that state government. This is State Transport Corporation.
Corporation.
They must have.
It does not apply to State Road Transport Corporation.
He has some different terms of recruitment, madam, and own guidelines is there.
For your STRC.
Madam?
For State Road Transport Corporation.
Madam, OSRTC, Odisha.
It's different. Not the same as state government.
They have not adopted that. Sometimes they adopt.
That's what I thought. You did not file counter before the single judge?
No, madam.
Then here at least you have to file a counter, sir.
Madam, it was disposed of on the first day.
No, you file a counter here at least.
My lord, I will file.
Since no counter affidavit was filed before the learned single judge, the stand of the opposite parties is not known. A direction is issued to the opposite parties to file that is OSRTC, to file its reply, clearly indicating whether there is any policy for regularization of contractual workers, particularly considering that the two appellants have been working on contractual basis since 2011.
Yes, ma'am.
Reply be filed within 8 weeks, rejoined up for the next date. 28th August. Yeah, so weekly, what will be weekly? Yes, yes.
Weekly list.
Yeah. Stay on board, we'll stay on board.
Weekly list past door matters. Item number 64.
I beg your pardon. The password item 4.
You're ready, then we'll have it.
I'm ready. I'm for the opposite party.
Who's for the whole thing is Mr. Mishra was not.
Mr. Narendra,
Senior
advocate Narendra Mishra.
Yes, sir. Are you ready?
My lords, I'm still not little well, but till then I was making one inquiry through my brief, your lordship. Is the LCR there with your lordship's brief, your lordship? Otherwise, I will make a compilation and put it up on Monday, your lordship.
All right. Let it come on Monday. All right. You make the compilations.
Yes, I'll make the compilation.
All right.
Grateful, your lordship.
Item number 64. Weekly list, item number 64.
The workman is challenging the award of the labor court, where the termination has been held to be illegal and unjustified, but the relief was not granted on the ground that the opposite party management is not an industry. The relevant findings, sir, my lord, at
club. It's a club.
Yes, my lord.
Valley Club is not an industry, sir. How is it an industry?
My lord, my lord knows that AIR 1978 Supreme Court 548, where the definition, the different organization, whether industry or not, that has been held, my lord. I have last time also supplied that copy of that judgment, my lord. There, my lord, it has been held that clubs will be industry subject to certain exceptions.
What exceptions?
If it is a self-serving club, then it is an exception, my lord. And what is self-serving, that is also reflected in the judgment, my lord. My lord, that last time I have supplied, my lord, kindly have a look at that.
Bangalore water supply.
My lord.
Bangalore water supply case.
Yes, my lord.
Stand.
In this case, I am appearing for the opposite party. Kindly, the award dated 12/10/2012. This was challenged in 12/5/2014. After 2 years.
That's all right, sir. All this.
And kindly come to the finding as page 42, page 10, paragraph 10. Now coming to the question regarding status of the second party, I find when the Valley Club was not regarded as an industry, it cannot be said to work on with the meaning of so. The second party claims to have been appointed by the Secretary Valley Club. He has specifically admitted during cross-examination that he does not know about publication of any advertisement or filling of the post of marker. He further admits that his name was not sponsored by the Employment Exchange for appointment in the said post. He was not issued with any interview call letter. During cross-examination, he has successfully specifically stated that one Sri Bimal Kumar Tripathi, working under the Tata Iron Steel Company, was looking after the affairs of the Valley Club, Joda, and he called him for the purpose of interview for the said post. He further deposed that Bimal Kumar Tripathi handed over the appointment letter to him and signed the appointment letter. The second party, however, has not filed any appointment letter issued in favor. He relies upon one letter dated so-and-so, marked and so-and-so, wherein it was mentioned that he has been appointed marker as per the advice of GM Nuamundi. The authenticity of the letter is seriously disputed by the first party. The aforesaid Bimal Kumar Tripathi was examined on behalf of the first party, who deposed that he was never holding the post of secretary, Valley Club, and he has not issued a letter in such capacity. He was not given any appointment letter, nothing. And this Valley Club was not registered, and some 10-12 officers, they sit together in a house, and that is called Valley Club for recreational purpose. Tata Steel officers.
No. I think the finding went in his favor that he was an employee. The only finding that went against him is that it's not an industry.
Yes, madam. That is also evidence of the management that I have engaged.
That's the finding, sir. That he's an employee of the club was held to be proved.
But running fetch, he has not paragraph page 7 of the award.
So para 12.
Para 12 is fine.
Achha, both issues are answered in the negative.
My lord.
So how do you justify the whole award, sir? Both issues went against you, that you're also not a workman.
My lord, the evidence of the management as page 32, my lord. That is their evidence that it is a fact that the workman named by the council had been engaged by us to look after the club at fairs at Valley Club Joda as a whole, and also to assist the players for the game called pool. That is it, my lord. Evidence starts from page 32. Relevant portion I am reading as page 34, para 11. That is the evidence of the management itself. Page 34, para 11. It is a fact that the workman named by council had been engaged by us to look after the club at fairs and at the club Joda as a whole, and also to assist the players for the game called pool. So engagement is not disputed by the management also.
The only question is whether it's an industry.
Yes, my lord. So far as industry is concerned, my lord, that decision, my lord.
Bangalore Water Supply.
My lord. This, my lord, so far as clubs are concerned, it starts from para 137, that is
137.
Page 588 of the judgment. Paragraph 137.
Yes.
My lord. Are clubs industries?
Yes.
The wide words used in section 2F, if applied without rational limitations, may cover every bilateral activity, even spiritual, religious, domestic, conjugal, pleasurable, or political. But functional circumstances spring from the subject matter and other cognate considerations already set out early in this judgment. Industrial law, any law, may insanely run amok if limitless lexical liberality were to inflate expressions into bursting point or proliferate odd judicial arrows which at random scent hit many an irrelevant mark which the legislative archer never meant. To read down words to yield relevant sense is a pragmatic art. If care is taken to eschew subjective projections marked as judicial processes, to true taste, as we apprehend from the economic history and functional philosophy of the act, is based on the pathology of industrial friction and explosion, impeding community production and consumption and impairing peace and welfare. This social pathology arises from the exploitative potential latent in organized employer-employee relationships. So, where the dichotomy of employer and workmen in the process of material production is present, the service of economic friction and need for conflict resolution show up. The act is to mean to obviate such confrontation, and industry cannot functionally and defunctionally exceed this object. The question is whether in a club situation or a cooperative or even a monastery situation for that.
Self-serving clubs. That is only subscription by members. Here something comes from the company.
Self-serving has been defined, paragraph 141, my lord. Even these people's organs cannot be non-industries unless one strict condition is fulfilled. They should be and usually are self-serving. They are poor men's clubs without the wherewithal of a gymkhana. That is a decision report which reacted this court for adjudication. Indeed, they rarely reach a court being easily priced out of our expensive judicial market. These self-service clubs do not have hired employees to cook or serve, to pick or change balls, to tie up nets or arrange the cards table, the billiards table, the bar, at the bath or do those elaborate business management course for the well-run city or country clubs. So, my lord, in
This
this
is
case,
not like that, correct?
in this case, my lord, evidence is there that so far workman evidence, engagement of workman evidence is there, my lord. So here is a employer-employee relationship was there. So it is not a self-serving club to out the definition of industry. And the evidence of the workman it shows that he has doing the as a marker. He is also doing manual and clerical nature job. He was engaged in different jobs and programs conducted at the Valley Club Joda, like making arrangement of sports, athletic competitions, cultural activities, and also looking after swimming pool and swimming competitions. He was also interested with the work of marketing of food articles, looking after preparation of food, preparation of dining table, serving drinks and serving of cooked food, etc. to the officers and their family members. All these things he is doing, and also
So the Gymkhana's case is overruled.
Hello?
They overruled Gymkhana case. They overruled
yes, my lord.
Cricket Club of India case also.
Well.
Yeah. Yes, sir. How do you get out of it?
Let him solve the copy and.
Sir, which copy?
No, give me the decision.
No, it's already there. This is Bangalore water supply, sir.
Just now here relied upon.
That has been in the input order, my lord.
My lord, the finding is that at page internal page 6, 43, paragraph 11. The order advocate for workmen submitted that Valley Club at Joda is operating over a land belonging to a Tata Steel Company Limited, and therefore the said club should be treated as a part of parcel of said company. He relies upon the certified copy of the ROR of Khatan so which reveals that the said company owns the Dharwari plot number so. He also relies upon an information collected under the RTA Act, part as W16, which above that over plot number 6, Tisco Limited has a house which is named Valley Club, Joda, and there is a volleyball and badminton field with a said plot. The second company further relies upon some paper publication which indicate that the Tata Steel Company arranges some functions in the Valley Club at Joda. It reveals from the oral evidence adduced by the first party that the club at Joda consists of members who are basically, and thereafter nothing is there. Paragraph 11 ends with that.
No, but this is neither here nor there. See,
but that law, and I think some lines are there below that, but the
which lines? Claim with the second party, there is an employee of Tisco cannot be adjudicated since the name of the said company is not mentioned. But that is neither here nor there. Only question is the club of an industry or not for the purposes of the ID Act?
And the paragraph 11 says that it is a function in a house. And some 10, 12 officers.
See, unless it's a self-serving club which does not hire anybody.
Let me take an instruction hold the take on Monday. I'll hold a self-serving governor on that point only. Take on Monday, I'll take an instruction.
You can't improve the evidence, my lord.
We'll stay on board, sir. We'll take it on Monday.
Yes.
Item number 78.
May I please, Your Lordship? A poor landless person Miller, a piece of land was leased out to him, and without any giving opportunity of hearing, the ADM has annexed 2 and cancelled the lease granted in favor. By order dated 3/11/2014, Miller, Your Lordship directed my land friend instead not to produce the records.
The records have to be produced, no counter filed. He says he's not been served. Not been heard.
Lordship may relegate.
So reply alone has been referred to, not his appearance. You see the challenge in the present petition. Is to the order dated 2nd September 1987, passed by the Additional District Magistrate, Bhubaneswar, in revision case number 441 of 1986, cancelling the lease granted to the petitioner by an order dated 30th September 1975, the Tahsildar Bhubaneswar, settling an area of AC 0.200 in plot number 1 in Khata number 255 in Moza, Swanga, in favor of the petitioner. Full stop. The fact that the suo motu revision was initiated under section 7, capital A, bracket 3 of the OGLS Act 1962, more than 12 years after the grant of the lease, so nearly 12 years after the grant of lease, does not appear to have been examined by the ADM. More importantly, while referring to the written statement filed by the opposite party, that is the present petitioner, questioning the maintainability of the revision petition, the presence of the petitioner or his authorized representative at the hearing is not even noticed by the ADM. Paragraph. One of the principal contentions of the present petitioner is that he was not given an opportunity of being heard before the impugned order was passed. He was not confronted with the materials on the basis of which it was concluded that the lease had been improperly granted in favor of the petitioner without a proper inquiry. Paragraph. With there being no counter affidavit filed in the present petition, till date, there is no contradiction of any of the arguments of the petitioner in the petition. Paragraph. Accordingly, the court sets aside the impugned order dated 2nd September 1987, passed by the ADM Bhubaneswar, and restores revision case number 441 of 1986 to the file of the ADM Bhubaneswar, where it will be listed on 10th April 2023. We'll stop on that date. The petition will appear along with the downloaded copy of this order. So, after hearing the petitioner afresh, and a reasoned order shall be passed by the ADM disposing of the said revision case within a period of 4 months thereafter. Till such time, the status quo as of today shall be maintained. The petition is disposed of. A copy of this order be sent to the ADM Bhubaneswar forward.
Weekly list, pastor matter item 97. 97.
May I please, Your Lordship? There's a matter under the Contract Labor Regulation and Abolition Act. The petitioners before Your Lordship have been working as a security personnel under the OPGC for more than 25 years under various contractors. Contractors, they go on changing, but these petitioners, they continue as security guard. And it is relevant to mention here, my lord, OPGC doesn't have any other security agency, either from the state armed force or any industrial security force or any paramilitary force. So OPGC solely rely on the security provided by these petitioners. But having worked for more than 25 years, these people are not regularized and they are asked to work under various contractors. Contractors, they go on changing, but these petitioners continue. So they approached this honorable court earlier in two writ application, which I have mentioned.
No. The question here is, sir, they have not abolished the contract labor in your organization.
That is exactly, my lord. That is the under challenge. Your lordship may kindly turn to Annexure 1.
Yes.
Annexure 1 of my account.
Yes.
Annexure 1 at page 16. Your lordship may kindly see. Page 16.
Yes.
The Honorable High Court of Orissa, in its order dated 16/2010 in OJC, has directed the State Advisory Committee and the state government to take a decision within a period of 3 months on the petition of the petitioner to abolish the contract labor system and to regularize the service of 131 security guards of OPGC. As per the resolution of 25th State Advisory Contract Board, a subcommittee was constituted under the chairmanship of Deputy Labor Commissioner Sambalpur to submit its report. The Deputy Labor Commissioner submitted the report of the subcommittee constituted on 9/8/2010. The report of the Deputy Labor Commissioner Sambalpur revealed that these 131 security guards are working under various contractors. The Deputy Labor Commissioner Sambalpur has suggested that the service of watch and ward job is not carried out through workmen on regular roles of the industry, though the security personnel are working in the establishment of the principal employers in slum. He has suggested that the board may consider to prohibit employment of contract labor system in an industry watch and ward. Then the board, after detail, last paragraph there, the board didn't consider the report of the Deputy Labor Commission. What is transpired from the report, Your Lordship, the board, after detailed deliberation of the report of the Deputy Labor Commissioner, came to a conclusion that watch and ward security service of the industry is not a regular perennial nature. This is absurd, my lord. Can anybody conceive that an industry would survive without security, my lord? Any industry, they need security. If it is not perennial in nature, how could they be allowed to work for more than 25 years from the date of inception of OPGC, my lord? Actually, without proper training and through security agency. Security agency, the security guard, how could they scrutinize what are the parameters for appointment of security guards on regular basis? There is no parameter, nothing else. And the management was satisfied with the service without any complaint. And we have been allowed to work, provide service without any flaw. So all these observations made by the State Advisory Board, which was presided by the Honorable Labor Minister, the then Labor Minister, without any material fact before them, they came to a conclusion and accordingly recommended. So, Mila, now the question is, Mila, when a committee constituted under the statute, Mila, can they pass any order without proper application of mind, without against the statute 10, my lord, section 10 of the Contract Labor Act?
Actually, the government has to then file a reply here. Because this is the government which has to now explain how do you come to this kind of a conclusion. How can watch and ward not be perennial nature? Power Transmission Corporation.
Yes, ma'am. So Your Lordship has seen that report. In that report, Your Lordship, I am reading that page 16 again, madam. That the Deputy Labor Commissioner suggested the services of watch and ward not carried out to the workmen on regular roles of the industry, though the securities are working the establishment of principle since long. He has suggested that board may consider to prohibit the employment of contract labor system in respect of watch and ward security services of the industry. Simultaneously, the principal employer may have to give preference to engage them in the establishment.
Yes,
that meant.
So here it is not my prayer for regularization directly, unless this is abolished. Contract labor system in respect of security services is abolished in the industry. There will be no scope for regularization.
This is a recommendation.
That's what. That is the first step, my lord.
May I permitted one line, Your Lordship. My learned senior has not challenged a special act is there. The Private Security Agencies Regulation Act 2005.
Yes,
I have specifically about that. The act has been provided the rules, regulations for deployment, the objects and reasoning for the.
That is not. I have nothing to do. I have no objection on that.
For one line.
Because this
was this act will declare the ultra virus.
No.
Because the act specifically provides the regulation, appointment, training, everything has been regulated by this act. So accordingly, they have to obtain a license from the competent authority. So how are the workmen affected by all this, sir? In fact, even in contract labor law, the failure by the principal employer or the contractor to get registered should not ipso facto affect the rights of the contract labor. No, sir, this is for watch and ward. And whatever. Security, right? A series of judgments are, then the government has to file a reply. And the series of judgments is that watch and ward cannot be considered. Cannot be considered for permanent appointment.
Security. That
security.
Is,
no, this
that
is watch
security.
and ward.
No, security. Security. Watch and ward and security.
This is watch and ward.
So the security personnel, that is the role of the industry. So the security personnel are working in establishment.
Watch and ward.
That is the finding.
Page 17. Page 17.
Yes,
referring to page 17.
That is the report.
Conclusion of the board.
Yes,
the approval.
Watch and word stroke
security services. Yes.
Security service.
In this case, I highly detailed counter so that
the counter is required also because the act has the
you also may kindly go through the counter filed by the industry millers. They have never mentioned that apart from this petitioners, they have any other person
carrying out these. If the age may be seen.
Security.
All right. The petitioners are 131. Security guards engaged at the work premises of the Orissa Power Generation Corporation Limited. Bracket opposite party number 3. So this is the second round of litigation concerning
third round of litigation.
Sorry, third round of litigation concerning their prayers for regularization of their services. Paragraph. Pursuant to an earlier writ petition filed that is OJC number 6416 of 2002, in which an order had been passed by this court on 16 February 2010 by the State Advisory Committee under the Contract Labor Regulation and Abolition Act 1970. Bracket CLRA bracket Act met and decided at a meeting held on 22nd September 2010 that the state government would be moved for open quotation non-abolition of the contract labor system, unquote, in respect of these 131 security guards. So the result is that for the purposes of Section 10 of the CLRA Act, the petitioners would continue to be only contract labor and cannot claim any regularization. Stop. Accordingly, the present petition, the first prayer is for quashing the above decision made by the State Advisory Board.
1 and 2, then the government notification. 2.
And it's only the consequential prayer, which is for regularizing their services after abolishing the contract labor system. Paragraph. Although reply has been filed by the OPGC, no reply has been filed till date by the state government. Paragraph. Considering the nature of the controversy in the present petition, the court considers it essential for the state government to explain the basis on which it decided not to abolish the system of contract labor. Full stop. In this context, the court would like to refer to the minutes of the meeting of the State Advisory Board, where it is sought to be opined that open quotation watch and ward / security services of the industry is not a regular / perennial nature of work. Full stop, unquote. Considering that the present petitioners have themselves been performing those tasks for over 2 decades now.
More than 2 decades.
More than 2 decades now. Due permission, that will be a wrong one. The state government will have to explain how an opinion is formed that such work is not open quotation, offer open quotation regular / perennial nature, unquote, full stop. Paragraph. Additionally, counsel for opposite party number 3 draws attention of the court to a special enactment.
Lordship, private security agency, the private security agency's regulation to Act 2005.
But are these private security agencies?
Lordship, yes, the object has been to regulate the security gas.
That's a different thing, sir. Let's see what the government says. Anyway.
Sir.
All right. The reply of the state government will be filed within 8 weeks. List in the regular matters on August 10th.
10th of August. 10th August. Can it not be early, my lord? Because after much persuasion, it would come as an old matter in the list. I have been trying to get it listed for last 1.5 years.
10th May.
10th May.
Lord, before your lordship takes up the matter, my lords, so one matter is the morning hour your lordship are dealing. That is WPC number 3529 of 2018, already dealing by judicial order. So this may be taken out from this list.
Yes.
Fine.
Yeah, that will be excluded. Correct. So who starts? You'll start.
I'll start, my lord. With lordship permission, my lord.
Yes. Oh, yes. Mr. Dwivedi, yeah, correct. All right. Good afternoon, Mr. Dwivedi.
Oh, he's listening.
Yes. You may have to unmute, sir. Yes. Now you're.
Good afternoon, sir.
Good afternoon. Yes. So we'll have the petitioners begin, sir.
Yes.
All right.
As the lordship, please.
All right.
So, the Entry Tax Act may be narrated.
Yes.
Before I start, Manoj, I'd like to place the date chart.
Yes.
To apprise your lordship with regard to the sequence of events and the facts relating to the subject matter of dispute.
All right.
But the date chart I have given with your lordship here.
Right.
The copy has been given to you, sir?
Yes.
Date chart?
Yes, I have.
Yes. Yes.
But if your lordship looks at the first page,
yes,
18/2/2008, the Honorable Court by a common judgment, the petitioner's in writ application 1887 of 2006 passed in Reliance Industries. That's a reported edition. So 2008, volume 16, VST 85. At para 30 of the said judgment came to hold that the state has no jurisdiction to impose tax on such goods imported from outside and are not manufactured within the state of Orissa. That document is Annexure 1. That judgment is also, I have Annexure 1 at page 84. I'll come to it later. Since the motor vehicle dealt with by the petitioners are not manufactured within the state of Orissa and are imported from outside the state to the local area, the petitioner's liability to pay entry tax local area had been seized
with
effect from CEA. That spelling is mistaken.
Right.
The CESST.
Yeah.
With effect from 18 to 2008, and accordingly the provisions of law or the OET Act in respect to the goods covered under para 30 became inapplicable, and the petitioners were not required to deposit the entry tax and had no obligation to file statutory return under OET Act from 18 to 2008.
Right.
The date is relevant for the purpose of adjudication. On 30/10/2009, the state of Orissa challenged the aforesaid judgment, particularly in para 30 of the Reliance Industry, because it has been held to be intra-virus. Therefore, para 30 was the only subject matter dispute in SLP, and the Honorable Supreme Court had been pleased to grant stay of the judgment of this Honorable Court. Further pleased to hold that state will submit a cut-off date intending to record that each and every assessee shall pay the outstanding amount as of cut-off date in installments within the time fixed by the court. The Honorable Court also made clear that if the state ultimately loses, it shall refund the amount with interest, which shall be fixed by the court. However, each and every assessee in this group of cases shall undertake to pay the outstanding amount in installments within the current liability that may accrue pending disposal of the SLP. The Honorable Court further made clear that the assessee in this group will have to deposit the outstanding taxes without penalty. Till the next date of hearing, no recovery of that for the time being. That is Annexure 3, that order is there at page 92 and 93. On 3/10/2010, the Honorable Court modified the earlier order dated 30/10/2009 and has been pleased to pass order that each of the assessee will, without prejudice to the rights and deposit with the department, 1/3 of the outstanding amount indicated in list A, list B. So list A and list B, two categories were there because manufacturers and dealers.
Right.
But as on 30th September 2009, before 31st March 2010, the assessees will also continue to deposit with the department the outstanding amount on the basis of the current liabilities which have accrued after 30th September 2009. That is 33 or 1/3% amount due in monthly returns, which each of the assessee have been filing with the department. That is also, we have Annexure 4 at page 102. The petitioner has made the compliance with the aforesaid order of the Honorable Supreme Court. On 31/10/2013, interestingly, the matter was still pending for the Supreme Court. The order of assessment passed for the period 1/12/2008 to 31/1/2013 by the assessing authority by holding that the petitioner had paid 1/3 entry tax, the Supreme Court directive, and no interest is payable as all the payments have been made in due time. Assessment results in nil demand. On 19/10/2016, the petitioner made objection to the notice for audit assessment, as the audit has suggested assessment on 9C of the OET Act. 9C may not be applicable, reason being the matter is pending there and the interim order has been complied with. by inter alia submitting that the petitioner had been paying the entry tax as per the order of the Honorable Supreme Court, that Annex 7 series at page 122. On 11/11/2016, the assessing authority passed the order of assessment for the period 1/4/2013 to 31/3/2015, computing tax demand and also imposing penalty, which is directive on the teeth of the order 30/10/2009. But that should not have been done, but that has been done. But on 28/3/2017, the final order that has been passed by the Supreme Court. 28/3/2017 is the main date, because I am emphasizing on that date, reason being, but prior to 28/3, we are considering with regard to the interest to be imposed. Interest prior to 28/3/2017, interest after 28/3/2017. So this date is relevant for that purpose. The Honorable Supreme Court allowed the appeals of the state by reversing the judgment of the Honorable Court passed in the case of Reliance Industries, and in view of the decision of 9 judges bench, Jindal Stainless Settlement, that was 2-3 months prior to that, the judgment was delivered. On that basis, the court has followed the judgment. That is, I filed it Annex 5 at page 105. On 26/5/2017, the Deputy Commissioner Sales Tax as well as the Sales Tax Officer issued notice in Form E8 demanding entry tax as well as penalty for the period 1/4/2013 to 31/3/2015 and 1/4/2008 to 31/3/2013. But E8, as your Lordship knows, the tax that is due on the required to be paid, that has to be demanded. But here, interestingly, I'll come to your Lordship the order. There it has been mentioned that the deposits we are going to make will not be construed to be tax. It will be construed to be deposits alone only. No way it will be converted to tax. With the reason being, we are in session of the matter, therefore it cannot be construed to be tax as such. But that order, sir, I have Annex 8 series at page 125. 26/5/2017, the Sales Tax Officer issued notice in Form E24. E24, my lord, is a result of interest under Section 7(5). Section 7(5) of the OET Act. The Sales Tax Officer issued notice in Form E24 calling upon the petitioners to pay 2/3 along with interest, treating the amount deposited pursuant to the order of the Honorable Supreme Court as a tax, and claimed the remaining amount to be short paid or less paid. Annex 9 series are the series of demand. Right. At page 129. 23/6/2017, the petitioners made challenge to the levy of interest as per Rule 10(6)(b) of OEA rules by issuing notice in Form 24. The notice for less payment of entry tax and penalty before the Commission of the Sales Tax Orissa. Also brought for grant of 150 installments. We also wanted that, so the 2/3 part is concerned, we have to grant some installments for payment of the same. He requested. During the currency of the proceeding, the Commissioner issued a circular by holding that the dealer shall be liable to pay interest as per the OEA Act from the due date as per tax return of the relevant period. This circular has been issued after the judgment passed by the Supreme Court, and they have interpreted in a way that this is a sort of income tax that's as per the return they have filed. Therefore, this amounts to coming within the purview of Section 7(5), and that is the reason why it will be tax will be levied. Interest will be levied. The Commissioner also came to hold that minimum 25% of the total tax component covered under notice in Form 8 and Form E8 and E24, or both will be paid by 29th June 2017. The balance component shall be with interest shall be paid in 3 equal installments. That is Annex 10 at page 155. On 24/6/2017, acting under the dictate of the state in compliance with the circular, the Commissioner passed the order. We challenged it in revision. The revisional authority passed an order without giving any finding whether the levy of interest under Section 7(5) of the OEA Act, read with Rule 10(6)(b) of the OEA rule, is justified or maintainable. But that was the subject matter of challenge before the Commissioner also. Commissioner didn't give any positive response to that, particularly when the petitioner deposited 1/3 entry tax and filed the statutory returns pursuant to the order of the Honorable Supreme Court, and the petitioner had never admitted any tax in the return. 8/12/2017, the Honorable Court, in a similar matter, in writ petition 21169 of 2017, has been pleased to direct the Chief Secretary. But what happened during the pendency of those matters after the disposal of the Supreme Court order, when the matter was challenged before this Honorable Court, this Honorable Court thought it prudent to direct a committee to be constituted by the state, and they should examine whether we are liable to pay interest or not, and to what extent we will be liable to pay, all those things to be gone into. If your Lordship wants to see that, that is very important at this stage to bring your Lordship notice. I think my friend has given a copy of that committee report. If your Lordship kindly look at this stage, that report is required to be seen.
Yes, that is in my memo of citation. Your Lordship, number 1 in memo of citation. No, the serial number 1, report of the committee constituted as per the order dated 8/12/2017 in WPC number 21,189 2017.
Right. It's that.
That is at page 1 to 17.
Correct.
Your Lordship.
It's 41. Computer.
Malad, got the copy, Malad?
Yes.
Yes, sir.
1 minute.
Yes.
You got it.
Yes, Malad. If your Lordship turns to, I don't want to take your Lordship the facts that has been dealt initially.
Yes.
And the interim orders passed by the Honorable Supreme Court. But if your Lordship kindly look at page 7, Malad. Page 7, subclass 4. Interim order dated 3/2010.
Right.
State of Orissa versus Reliance Industries. There, if your Lordship turns to page 8.
Yes.
It reads like this. The department has submitted a list containing the names of traders as also names of manufacturers who are, according to the department, in arrear of tax, which is the subject matter of challenge before us, as on 30th September 2009. In this case, concerned Bhushan Steel Stripes Limited, according to the department, as on 30th 9, those are manufacturers, Malad.
Right.
If your turns to the other one, before, as far as current liability commencing the 1st October 2009 is concerned, the SSC will pay entry tax on ad hoc rupees of 30 lakhs per month. This is regarding the manufacturers. It says before concluding, it may be mentioned that State of Orissa will also file affidavit undertaking to refund the amount in event of state losing its case with interest to be fixed at the final hearing of the matter. Such an undertaking will be given by the Chief Secretary of the state. We make it clear that the amount which are also directly to be assessed to pay shall be treated as deposit and not as a tax till hearing and final disposal.
This is for your submission that this can't be short payment of tax.
Yes. Then your Lordship kindly turn to page 10. In regard to rest of the interlocutory applications,
yes,
the manufacturer and the traders.
Yes.
In this batch of interlocutory application, the department has furnished to the government a list A and names of manufacturer in list B, excepting Bhushan Steel and Stripes Limited, Bhushan Energy, Vedanta Limited, and Reliance Industries, whose cases have been dealt with separately. We are required to pay entry tax up to 30th September 2009. Both these lists are covered by para 30 of the improved judgment. Having regard to the outstanding amount in list A, list B, mentioned herein above, we are of the view that each of the SSC will, without prejudice to his right, deposit with the department 1/3 of the outstanding amount indicated in list A and list B as on 30th September 2009 before 31st March 2010. Each of the SSC will also continue to deposit with the department the outstanding amount on the basis of the current liabilities, which has accrued after 30th September 2009 at the rate of 33.5, 1/3 of the amount due to the monthly return with which each of the SSC has been filing with the department. It needs to be clarified that this order is confined to cases falling under the paragraph 30 of the impugn judgment. As far as the item which are not covered in paragraph 30 of the impugn judgment is concerned, liability is given to the SSC to liberty is given to the SSC to move separate interlocutory applications. Before concluding, it may be mentioned that State of Orissa will file an affidavit undertaking to refund the amount in the event the state losing its case with interest to be fixed at the final hearing of the matter. Such an undertaking will be given by the Chief Secretary of the state. We make it clear that amount which are directed by directing the SSC to pay will be treated as a deposit, not as a tax, till hearing and final disposal of the matter. The interim order passed on 30th October, to the extent indicated, stands modified. The traders, that's, if Lordship then turn to page 12. With regard to interest liability, the committee, after thoroughly examining the provisions of the Odisha Entry Tax Act and rules, the order of the Honorable Apex Court and also the written submission made by the parties has analyzed the issue as given below. It has been argued by the parties that 1/3 amount of entry tax, which has been directed to be paid by the Honorable Supreme Court in its order 3/2010, has been treated as deposit and not as a tax. Subsequently, it has been decided by the Honorable Apex Court by this final order 28/3/2017 that entry tax is a tax within the plenary power of the state, and parties argued that interest is payable only after the final judgment is made and not from the date of the interim orders, on the ground that it was to be treated as deposit at that point of time. The argument of the parties will not come to their help in as much as 1/3 of the total liability is to be treated as deposit with government, and interest bearing on the remaining 2/3 of the liability is also to be similarly treated as deposit with parties. The interest bearing. The law relating to part is same as law relating to the whole. It must prevail uniformly on both the parties. It cannot be argued that interest is only payable by the state by virtue of the interim order dated 3/2010 when the state loses, and not by the parties when the parties lose. Such a partition and discriminatory view of law between the two parties is not possible. Therefore, parties have lost and are liable to pay interest in the like manner. State would have paid interest had it lost. Now, they have quoted the Supreme Court order that if the state loses, then they have to pay interest. But there has been no specific order so far the parties are concerned. The most important aspect of the interim order of the Honorable Supreme Court is that Honorable Supreme Court never held the parties not liable to entry tax during the period of the case was sub judice. But though it has not been held, but still then it was accepted to be a deposit because they were yet to finalize whether it will be a tax or not. In every case, the Honorable Court has directed the parties to pay fixed sum amount against current liability or 1/3 of the current liability. The Honorable Court had also directed the parties to file monthly returns. Therefore, the fact is that the parties during the sub judice period were always under the liability of paying entry tax as per the said act. The only relief the Honorable Apex Court had given to the parties was on account of the partial payment of their outstanding liability. Liability as on 39/2009 by 30th March 2010, and partial payment of their current liability, is liability accruing after 39/2009 on a monthly basis. Therefore, contrary to the claim of the parties, they were always under the full liability to pay the entry tax. That is how the committee tries to interpret in their own way. The Honorable Apex Court has never held the parties would not be liable to pay interest on the withheld portion of their entry liability. But there was no such finding and no such interpretation by the Supreme Court also while passing the interim orders. Had it been so, the Honorable Apex Court would have stated so in an unambiguous way as stated in case of penalty. Charging interest is a substantial provision of the Odisha entry tax. Correct law. That is the correct position. When the entire act was held valid, the provisions of interest would have been valid exactly in the way it is provided for in the act. Nothing can be added or to delete from the provision of interest on the plea of protracted litigation causing huge interest burden on the parties. The Honorable Apex Court in so-and-so case have already settled that the provision of the statute is to be strictly construed, giving importance to each and every word of its clearest meaning. Interest can be levied and charged on delayed payment of tax only if the statute that levies the charges, the tax makes a substantive provision in that behalf. In the taxing statute, there is no room for any intendment or presumption. One must look fairly at the language used, as has been held by Baidyanath Ayurved Bhavan versus Excise Commission in UP. In interpreting a taxing statute, the court should not ordinarily concern themselves with the policy behind the provision or even with its impact. In that case, the Apex Court referred with approval of the observation of the Rowlett, Justice Rowlett in Cape Bhandi Syndicate. In a taxing act, one has to look at what is clearly said. There is no room for any intendment. There is no equity about a tax. Nothing is to be read in, nothing is to be implied. One can only look fairly at the language used. It is extremely pertinent to refer to the same order of the Honorable Apex Court, Letter 3010/2009, pertinent to Entry Tax Act of Haryana State Government. Relevant provisions of the said order is reproduced below. It is pointed out that levy of entry tax has been struck down by the Punjab and Haryana High Court. In the circumstances as of today, we cannot direct the assessee to pay the taxes under the Act, which is held to be unconstitutional. However, each and every assessee in the group of cases will file its return within a period of 4 weeks from today. The assessing officer will wait the returns and pass assessment order in accordance with law. However, there is no recovery of tax till the further order of this court. Subject to each and every assessee in this group of cases giving an undertaking to the state and to this court that in the event of their ultimate losing the matter, they will pay the amount due with interest at the rate that may be fixed by the court at the time of final hearing of the matter. The said undertaking will be given within 4 weeks.
So the Haryana cases, the SSCs were clearly put on notice.
Yes.
That they would have to pay interest if they lose.
Right.
Whereas in your case, this was not specifically said. That's the point you're making.
That's the point. But Fellowship, they have analyzed the issues in their own way. And eventually, Fellowship looks at the recommendation of the committee at page 16.
Yes.
In the light of the analysis made above, the committee recommends the following guidelines for waiver of penalty, payment of interest at the reduced rate, and grant of other concession specifically as follows. Penalty should not be levied or be imposed for non-payment of withheld amount of entry tax if there is no suppression of turnover. However, suppression of turnover, if any, should be dealt with in as per law, and levy of penalties should be permissible by law. The parties are as such liable to pay interest as per section 7(5) of the Odisha Entry Tax Act on the withheld amount to 2% per month till 36/2012. But this 2% has been amended in 2005, I think. It has been made 1%, in fact. And 1% per month thereafter, as the Act was amended with effect on 1/7/2012, reducing the rate of interest till full discharge of their tax liability. However, the parties are expressing their inability to meet the huge financial burden that has fallen on them after the case was finally settled by the Honorable Supreme Court after protracted litigations. Their concern is that if the financial burden on them is not reduced, they will have no option other than stopping their business activities, which will make hundreds of employees jobless. They stated that if their business is stopped, state government will not get the routine normal tax from them, which will affect state revenue adversely. They also stated that the rate of interest at the rate of 2% per month is too high for them to bear, and therefore, on careful consideration of these grievances of the parties, it is recommended that the state government, for public interest, by way of ensuring survival of these business activities, may consider to waive the interest burden on the parties up to 36/2012 to the extent of 1% per month. That is, effectively, the parties will have to pay interest at 1% per month for the entire period of delay till full discharge of their tax dues. Additional time up to the maximum of 5 years from the date of order of the Honorable Apex Court, time up to 28/3/22, or for convenience up to 31/3/22 may be given to the parties by the Commissioner and the case-to-case basis for full discharge of the tax dues, along with interest 1% per month for the entire period of delay till full discharge of the tax dues. These recommendations are applicable only to those parties who are obtained the interim order of stay or interim order from the Honorable Supreme Court or Honorable High Court regarding observation of the Honorable High Court in para 30 of the order dated 18/2/2008. Secondly, only after the parties withdraw their cases from the Honorable High Court and Honorable Supreme Court, if any, the recommendation will be submitted to the state government for appropriate decision. Neither this recommendation nor the decision of the state government thereon shall be cited as precedent in other cases under the Odisha Entry Tax and Tax Act. But this report was placed before the Honorable Court, my lord. At page 9 of my note, my lord, if you should kindly turn. Page 9 of my note.
Yes.
On 24/4/2019, after the report was furnished in the court, the Honorable Court perused the report of the committee and is pleased to hold that, pursuant to the recommendation of the committee, all these matters requires consideration. That is why the matter is before your lordship. This is the background of the case so far as the factual aspect is concerned. And I have also taken note of those legal submissions I need to be made before your lordship. If your lordship permit, I can place it before your lordship.
Yes,
Your lordship's appraisal.
Yes.
Submission 1, the petitioners most respectfully submit that interest under section 7(5) read with rule 10(6)(b) can be levied in the event the petitioners fail without sufficient cause to pay the amount of tax due per return, and the petitioner has never admitted the entry tax liability in the return. The turnover of the goods relating to scope of para 30 of the judgment of the Reliance industry was only reflected in the returns, which would not tantamount to say that the petitioner admitted the liability. There was sufficient cause for the petitioner not to pay the full amount of tax.
Can we just read at this juncture 7(5)?
Yes, madam. If your lordship looks at this section 7(5), read with 10(6) and C,
yes.
10(6) and B of the rules. If I read section 7, section 7 actually starts with return and return defaults. Every registered dealer and every dealer who is liable to get himself registered under this act shall furnish every month to the commissioner a return in such form by such date as may be prescribed, and shall furnish along with such return satisfactory proof of payment of tax payable by him under this act, provided that the dealer who files quarterly return under the VAT Act may furnish return under this act every quarter, paying the full amount of tax as payable for the preceding quarter.
In none of these cases is there any situation of non-filing of return.
Yes, right. None of the cases are non-filing of return.
It's only not paying tax as per the return.
Yes.
As per the order of the Honorable Supreme Court.
But yeah. Let's be kindly look at subclause 5.
Yes.
Where a dealer, because one requires section to file, where a dealer required to file return under this section fails without sufficient cause to pay the amount of tax due as per the return for the said tax period, or fails to furnish return. These are the two contingencies, my lord. Fails to furnish return, such dealer shall be liable to pay interest in respect of the tax which he fails to pay according to the return, the tax payable for the period for which he fails to furnish the return, at the rate of 1% after amendment, actually 2012 amendment.
So 5(2), I'm presuming, does not apply here.
Yes.
Because all of you have File the return.
File return.
But in file 1,
if fails to pay according to the return.
According to the return. So whatever amount you show in the return,
yes,
you must fail to pay that amount that you show in the return.
Correct. Here what has happened, Honorable Supreme Court directed you pay 1/3.
So you showed 1/3 in the return.
Yes. So we never, without any sufficient cause, that what is very important here to be read, but it's not that we intentionally avoided to pay on the basis of the return we filed. Because the Honorable Supreme Court directed you file return, continue to go on filing return. And that has to be, and you have to pay 1/3 of the amount as per the, you have shown in the return itself.
So that without sufficient cause has to be interpreted.
Right.
All right.
And that amount will not be construed to be tax. That amount, 1/3 also, will be
because of the Supreme Court clarifying that it is not tax.
Not tax.
Although you show it in your return.
Right.
You showed that 1/3 as tax in your return, but because Supreme Court clarified that it will only be deposit, you're trying to say that is not tax.
Correct.
All right.
And that payment of the showing in the return.
No, but
tax,
even if it is taken as tax, since you showed that amount as tax and you have paid that amount,
right?
It's not failure to pay what you showed in the return.
Correct. That is exactly.
I'm sorry to interrupt. No, they disclose the full amount as per their own self-assessment.
Right.
Which is due under the Act, but paid only that lot which the Supreme Court permitted them to pay.
All right.
So X amount was mentioned, but 1/3 X was paid.
That is not that is a deposit. It was never a tax.
That is already.
Sir, actually that amount, full amount has been shown in the return.
Right.
There is no concealment.
Right.
We have not avoided that. We have not shown any full return itself. In the return, it has been shown full. The question arises here that the non-payment of the 2/3, whether it's the fault of the assessee or not.
Was that without sufficient cause?
Without sufficient cause. That is the crux of the matter.
Right.
But your lordship have already held in other decisions. I'll come to that, referring to Food Corporation, that its only tax can be levied after the judgment is passed, because the non-payment was not by the assessee's fault. Therefore, this balance amount was not paid, not because of our fault. Because the Honorable Supreme Court said you hold on. Until that period, the amount was non-existent for the purpose of paying tax. As per the order of the Supreme Court. But if your lordship kindly see another interesting thing, clause 10, lordship kindly see.
Yes.
They have not done clause 10, 11 also not followed. No. Clause 10 says, each and every return in relation to any tax period furnished by the dealer under this section shall be subject to scrutiny by the assessing authority to verify the correctness of calculation, application of correct rate of tax and interest, claim for deductions, if any, under the Act, and full payment of tax interest payable by the dealer for such period. 11 says, if any mistake is detected as a result of scrutiny made under subsection 10, the assessing authority shall serve a notice in prescribed form on the dealer to make payment of the extra amount of tax along with the interest as per the provision of the Act by the date specified in the notice. But this 10 and 11 has not been followed. What they have done, they have issued the demand notice on section E8 and E24, the interest. There will be non-compliance of 10 and 11 as such. There is no assessment held thereafter. But if your lordship kindly turn to Rule 10, Subrule 6B. Rule 10(6). If your lordship looks at clause 6, Rule 10,
yes.
Clause 6, each and every return in relation to any tax period furnished by the dealer shall be subject to manual and system-based scrutiny. if as a result of such scrutiny, the dealer is found to have made payment of tax less than what he is payable by him for the tax period, as per the return furnished, the assessing authority shall serve a notice in form E1224. Am I clear on it? Upon the dealer, directing to pay the balance tax and the interest thereon by such date as may be specified in that notice. Here, this can only be done after 10 and 11, Rule 10 of Section 7.
After scrutiny.
Yes. That has not been done. And they have simply issued notice.
This is the result of the scrutiny is this.
Yes.
Scrutiny happens there.
Right.
Here after Supreme Court judgment they have done.
Yes. What they say, after Supreme Court judgment, just issued the demand notice. E8 and E24. Referring to that Section 7.5 read with 10.6.
Yeah, but these kind of points won't get you far. It will only put you back for them to do that. So again, you will have to come back to the main question.
So what I mean to say, they have not complied with this.
No, but I'm saying this kind of a point will not.
Right.
Your lordship judgment has quashed a notice in case I have given that copy of that Toyo engineering. There your lordship have held that E24 notice cannot be issued unless
I know. So it all means, Mr. Mohanty, it will only mean that they'll have to follow that procedure.
Yes.
But it will still not answer the main question that you people are raising.
Right. But your lordship is absolutely correct. I just wanted to bring your lordship notice about this.
Yes.
But here what has happened, till the interim order was passed, so you kindly visualize one thing. Till the interim order was passed, there was no occasion to file a return or file a deposit. After the interim order was passed, it's a 1/3 deposit. 2/3 deposit was never intentionally, without any sufficient reason, has been avoided to be paid or not deposited. In 28/3/2017, when the judgment has been passed by the Honorable Supreme Court, that actually the interim order merged with that, and we were liable to, because Section 30 has been set aside. The paragraph 38 of the judgment has been set aside.
That's for 2008 to 2017. That reliance judgment is in 2008. From 2008, no tax is payable as per judgment of your lordship bearers. And that continued till 2017, when it was overturned by the
28/3
not payable at all.
So after the judgment was delivered, it was considered only you are liable to pay tax. And we deposited the amount.
So anyway, post 2017, there's no doubt at all.
Yes,
correct.
They're only pre 28 March.
And two judgments of your lordship in the case of Reliance and National Aluminium, the act is not operating.
Yes.
And my lords, just an additional point, in the case, in our case, which is for Sony India, there is a little bit of a confusion even post 2017, because our matter was not disposed of with the Reliance matter, but after it was disposed of 6 months later with Father William Fernandez. So that is an additional point that occurs in our case.
All right.
But judgment I have given you also, but I have not forgotten. Spiral bound. That was spiral balloon nice, sir. This was filed earlier.
It starts from JK synthetic.
It starts with JK synthetic.
Bajaj Auto, your lordship find my notes, page 32.
Yes.
Your lordship at page 35, para 9 and 10. You're a very short paragraph. Can I read this to you?
No, let him, Mr. Monty, let Mr. Mishra finish. I'll hear you in sequence.
Okay.
All right.
But your lordship, trying to look at that Bajaj Auto Limited case.
All right.
I was also citing that judgment.
Yes.
Paragraph 10, my lord, if your lordship kindly turn.
Yes.
So this is a matter regarding surcharge, my lord.
Yes.
However, as regards the levy of interest, since the legal position got clarified by the Supreme Court on 20th October 2016, the petitioner is justified in contending that the strength of the judgment of the Supreme Court in Food Corporation of India versus State of Haryana, that such interest is payable only for the period subsequent to the judgment of the Supreme Court and not prior thereto. Consequently, the impugned demand notices are modified only to the extent that the interest on the differential tax amount will be payable by the petitioner for the period subsequent to the judgment of the Supreme Court, the 20th October 2016, to the date of payment. The Deputy Commissioner of Sales Tax will now issue fresh order of recomputing the amount payable on the basis of the above modification, not later than so and so much. But here, one thing I would like to bring your lordship's notice. The Food Corporation judgment also I have given in that that is page 53, if your lordship looks at.
This is that compilation.
Kindly turn to paragraph 10, 11, and 13. But I have got spare copies, but if your lordship kindly allow me to give them. Paragraph 10, if your lordship looks, my lord.
Yes.
As we have noticed herein above, so far as the state of Haryana is concerned, during the period between 17th May 1975 to 6th June 1997, the new law declared by the Honorable High Court, the High Court was that the state of Haryana did not have the constitutional authority to impose sales tax on levy transactions. This declaration of law was not challenged by the state. Per contra, the state of Haryana accepted the declaration of law made by the state High Court, and therefore, until the position of law stood changed from 6th January 1997, the state of Haryana could not have made a demand for the payment of sales tax on levy of transaction. The demand notice by which the state claimed the tax for the assessment year of 76 to 75-76 was of the year 1982, which fell within the period when the law did not permit the state of Haryana to impose sales tax on levy transactions. Therefore, on that day, when the notice of demand was issued for payment of sales tax for the assessment year 1975-76, the demand was without authority of law. Subsequently, the state of Haryana could not have made such demand only after the judgment of this court, which was delivered on 6th January 1997. There is no doubt that by the judgment of this court, the right of the state Haryana to collect sales tax would date back to 1975. But that is not the same as saying that during the said period when the law was adverse to the state of Haryana, it could still have made legitimate demand because, as stated above, during that period between 75 to 97, the state's authority to make a demand was eclipsed because of the law declared by the High Court. The declaration of law made by the court now empowers the state to raise a demand even for the assessment year 75-76. The appellant is bound to satisfy that the said demand, but the duty of the assessee to satisfy that demand would arise only when the fresh and valid demand after the judgment of this court is made by the state. If the assessee fails to pay after the fresh demand is made, then as contemplated under section 59 of the Haryana Act, the assessee becomes liable to pay interest thereon. There is a charging section also, section 59. Let's kindly visualize. Interest can only be charged if there is a substantive law incorporated in the statute itself. There is a charging section. But then, if your lordship turns to paragraph 13, Malad, the further question, therefore, is whether on the demand now made by the respondent on the appellant, the state can also claim interest. We have noticed that the power of state to collect interest arises under section 59 of the Act. The said section authorizes the state to collect interest on belated payment of tax demanded but this payment of interest can be levied on such belated payment of tax which is legally payable, for which a valid demand is condition precedent. As has been noticed by us, the demand notice of the year 1982, which was issued during the period when the state had no authority to levy sales tax, cannot be said to be a valid demand, based on which interest could be claimed. A valid demand for the assessment year 75-76 could have been made by the state of Haryana only after the judgment of the court from 6 January 1997. And on such a demand being made on the February 20th, 1997, the appellant has satisfied the said demands within the period available to it. If that be so, in our opinion, state could not have demanded interest on the tax due on the assessments of 75-76 and based on its earlier demand of notice. So my respectful submission is that this judgment is squarely applicable to our case, where the statute was, the Honorable High Court declared as per para 30 that it is still not applicable.
Only one distinction, which I think you also probably noticed in para 10. State of Haryana accepted the declaration of the law made by the High Court, and therefore, till the position laws to change, the Haryana could not have made. So this declaration was not challenged in that case. The declaration by the High Court of the invalidity of the law was not challenged there.
Yes.
But here they could contest, since they've challenged.
Yes.
Whenever they succeeded in the challenge,
right,
it is as if the law continued unhindered from the day it was passed.
Yes.
So there was no eclipse. They could argue here there's no eclipse as such because it's only interim order. It's as if the law is always applicable from the day it was passed. That could be the argument.
The turning point here is, as you also rightly indicated, Malad, I should have clarified. Actually.
So I think much will turn only on
sufficient reason.
Sufficient.
Yes.
That's all. That's all.
Sufficient
if you say we had sufficient cause not to pay,
yes,
that's one thing.
Right.
So whether you're having succeeded, like Mr. Sahu is pointing, whether you're having succeeded and that position not having changed till 28th March 2017,
correct,
whether that was sufficient cause,
yes,
for you not to pay.
Right.
That is the only question.
That is the main pivotal point so far as this case is concerned, Malad. There was sufficient cause to show that yes, the reason for non-payment of the 2/3 because of that reason.
Like if you go on a balance of convenience argument, you having succeeded in the High Court and that order having been stayed only subject to conditionalities, you could not have imagined that you were anyway liable.
Right. And that is the reason why the Honorable Supreme Court has given a line, the state loses.
That's right. So that's the balancing of interest.
Balancing, right.
So nobody could have anticipated how it would go.
What is the eventual result in the writ application? Not that writ has been allowed by the time the interim order was passed. Another interesting thing is, you should kindly see.
Because there are certain other orders, like we pass now, we'll say that you continue paying the tax.
Yes.
And it will be subject to the outcome of the writ petition.
Subject to outcome.
So if the Supreme Court had said that.
That is different. That is not the case.
Continue paying the tax.
That is not the case here, Lord. They have also said it will not be construed to be tax. Because they also visualize, eventually it may not be tax at all. So that is one of the factors actually Lordship to consider. But here, if your Lordship kindly take note of one of the things, the Supreme Court passed an interim order. Sir, interim order of stay doesn't wipe out the order as such, unless it is set aside. Supreme Court has said 90 to Supreme Court. It says it has been stayed when further course of action has arrested. So the effect of paragraph 30 remains till 2017.
No, and you could perhaps argue that respecting the judgment of the Supreme Court, which revives the act from the day it was passed, you have anyway paid the tax.
Yes. That's correct. Absolutely correct, Parag.
You have not disputed your liability to pay tax.
Yes, I have not disputed.
Even during the period when the act was not operative.
Each one of them agreed. Yes, we'll pay. But the question here was that why the committee also recommended, or also we also approached the authority for the same, that we say grant us installment. There's a huge amount outstanding. We have not collected tax. We have not collected, in fact. So we say we have to pay the money in any event. So grant us installment to pay, and most of them have paid. Most of them have paid on installments and they have cleared. But some few are still outstanding because of the amount is huge. It differs from SSC to SSC. But this is so far as prior to 28/3/2017. we are not liable to pay interest because 7375 is not applicable to us. Sufficient reason is there for non-payment of the tax or of the rest of the amount. But here another question arises. If you also kindly visualize, after the judgment was passed, it has been paid the balance amount. Am I clear? The balance amount means it is actually outstanding amount, not on the basis of the return we did not pay. Or now the accumulated amount is either due to pay, not on account of the return, but it's the amount which is already existing. So there must be a charging section to show that for payment of that you will level interest. Because the relevant time is a period relating to that prior to period. That prior period non-payment was not due to without sufficient reason. So now section 7.5 cannot be made applicable for regarding the payment of the balance dues.
No, but you have disclosed the entire liability in your return.
Yes. But so, the thin line of distinction, let me clarify, Lord again, repeat, Malad. That amount due, as per the return we have to pay, we did not pay because of the Supreme Court order. So for till 28/3/2017, the non-payment was justified. Therefore, 7.5 cannot be imposed to impose the interest as per the statute. After the order was passed, but for that period, we are not liable to pay interest. We are liable to pay interest of the balance amount, which is now outstanding. The outstanding amount is a collection of the due, which is an arrear. Arrear amount can only be paid and we have agreed to pay. There is no provision in the statute to levy interest for the arrear amount. Under such circumstances, it is not in regular feature of it that we did not pay. We suppressed. All those things are there. Therefore, that amount which is now due as arrear, we are entitled to pay. We are paying it. And we have paid. They are now charging interest on that. There is no provision in the statute. But for your Lordship's appreciation, but all the judgments I have cited also, there must be a charging section to impose interest. 7.5 is a charging section. But 7.5 is not applicable to us. So 7.5 cannot be attracted for the arrears after the judgment is passed. Therefore, unless there is a separate charging section, we will not be liable to pay. But if Your Lordship kindly turn to a parametric provision in another statute, Maran.
No, let's just try and understand this under 7.5. Let's say you've disclosed 1,000 rupees as the total tax liability, right?
Yeah.
And you have paid 330 rupees under the Supreme Court's 333 rupees under the Supreme Court's order.
Yes, yes.
You still have to pay 666 as per the liability disclosed in your return.
Yes, this disclosed the return.
So why would interest not be payable on that 666?
So there is a
sufficient cost.
But there is no such provision to pay the same after it becomes an arrear, outstanding amount arrear. But I can understand, I deliberately did not pay, I'm liable to pay interest. This is not a case here. This is a case where actually these are the balance amount outstanding as arrear I have to pay. But this amount is not that I did not pay deliberately. That was 7.5 may not be attracted. If Your Lordship reads 7.5,
right.
7.5 cannot be attracted. There must be a separate statutory provision which can levy interest on that balance amount as arrear. I would like to take Your Lordships to that OVAT Act, Malad. So kindly have a look at the OVAT Act, Malad. Just for Lordship's appreciation, Malad. So a parametric provision.
So it can be a late fee, for instance.
Late fee.
There can be a late fee.
But Your Lordship may, with Your Lordship's discretion, say that yes, you are liable to pay annually 5%, 6%, or 9%. As Your Lordship may think.
We can't legislate anyway.
But there is no statutory provision. There is no statutory provision. But kindly look at that OVAT Act, Malad. Section 34. Yes, okay. Overtake section 34, let's see, can you see?
Yes, yes, default in filing return.
Section 34.
Yes.
(34)(1) small a, where a dealer, the 34 says default in filing return, where a dealer requires to file return under section 33A fails without sufficient cause to pay the amount of tax due as per the return, revised return or final return as the case may be, for any tax period. Same language as the other one. Then C, small c, fails to furnish return, revised return or final return as the case may be. There also it is fail, surplus 2.
D fails, yeah.
Small I, that's what you kindly see.
Yes.
That such dealers shall be liable to pay interest in respect of the tax which he fails to pay according to the return, revised return or final return as the case may be, for the tax payable for any month or month within the prescribed time.
So this is that late payment.
Perimetry to section 7.
This is exactly perimeter to section 7.5.
7.1.
7.5.
7.1.
7.5. 7.5.
No, 7.5 is only 1A. 34(1)A equals 7.5.
So
other subcategories are not there.
C also same alert.
D. A and D. A and D is also there.
A and D. So fails to amount of tax for any amounts in the manner prescribed.
Where dealer.
5 says.
No. The only difference is
D is not there.
For 1D does not have this without sufficient cause. Whereas 7.5 has without sufficient cause.
Yes.
So it's a major difference. That's a major difference. Here, mere failure will attract it.
I bowed on all
that.
That is
so
a big
this kind of a language may have helped them enforce it.
But I have got
if they had not prefixed it without sufficient cause, mere failure, it's like a no-fault liability. Mere failure would mean you have to pay interest.
But what I beg to submit, Malad, can you look at section 50, Malad? Section 50, subsection 5. Overtake, Malad. Section 50 time.
That's right, within 30 days. Penalty.
Payment and recovery of tax, interest and penalty.
Right.
Subclause 5, let's kindly see, where the dealer fails to make payment of tax, assess, interest payable and penalty imposed or any other amount from due from him under this act within 30 days of the date of service of the notice of demand, the assessing authority shall, after giving dealer a reasonable opportunity of being heard, direct the parties dealer shall pay in addition to the amount due from them by way of penalty a sum of 2% of such amount, interest, penalty or any other amount due. This section 50 provision is not there. This is a charging section, Malad. Substantive provision in the statute, which is silent so far as this act is concerned. In addition to that, sufficient cause, as you have rightly indicated. But this is not like an income tax act that if I don't pay, I have to pay interest.
Advance tax.
Advance tax, right.
Or
34A, B. Yeah.
But I have also given the judgment that there must be a charging section to impose interest. Without any charging section, actually, because 7.5 is not applicable. Therefore, you cannot impose interest on any other provision which is silent in not in the statute itself.
Yes. All right.
Well, that is the sum and substance so far as the legal points are concerned on the basis of the fact that is there before the Lordship.
So what have post 28th March, on what basis have you paid interest on the delayed payment, on the period of delay?
No, we have not paid. We have not paid.
Oh, after 28th March, you have not paid interest?
No, we have paid the amount on installment.
Tax amount.
Tax.
No, tax amount.
I thought the order said interest.
Order, your lordship on 2019 interim order, your lordship was directed to pay interest from 28th March 2017.
That's what I thought.
Till the date of deposit, and your lordship in that case, your lordship, so far as the interest from 2010 to 2017 will be adjudicated now, your lordship, at the time of final hearing, your lordship. That was the direction.
Sir, those are all, with due respect to my friend's statement, without provisional arrangement, till the matter is adjudicated. Two batches of writ application are pending for your lordship.
No, so you have paid interest without prejudice to your rights and conduct.
Correct. Yes, absolutely correct.
That's all right. That's all right.
Your lordship, that interim order is very
That is
clear.
clarified.
Your lordship decided.
But it's obviously without prejudice to the rights and conduct.
Sir, it has been clarified in the order itself.
Yes. No, but you have paid interest. That's what I'm saying.
After that,
After 28th March.
After that. As per the order of this Honorable Court.
All right.
The matter came in different batches.
All right.
But if your lordship kindly visualize one thing, Marad, page 47 of the compilation. No, I'm sorry. So WPC 13644, if your lordship looks at 13644 of 2020.
It will be further down the batch.
At page 82, if your lordship looks at the operative portion of the commission's order.
One more. Sorry. No. 13644.
Paragraph 7, Marad.
Sunny Motors.
Yes, Marad. Sunny Motors. That is that post. That relates to the post period, Marad. Page 82, if your lordship turns, Marad.
Yes.
Their lordships have referred to a judgment of this Honorable Court that by passing an interim order, paragraph 7, the above observation follows the order of the Honorable High Court in Jindal India Thermal Power versus Commissioner of Commercial Tax. They, considering the fact and submission made, the prayer made on behalf of the petitioner company is allowed. The petitioner company is directed to pay the outstanding Odisha entry tax dues pertaining to the period 1/4/2010 to 3/4/2017, amounting to so and so crore in 36 monthly installments starting from 1st September 19. The amount, if any, already paid by the petitioner towards outstanding Odisha entry tax for the aforesaid period shall be adjusted in the aforesaid installment. However, so that is the reason why we are paying Marad. However, the petitioner company will pay 12% interest per annum on the outstanding Odisha entry tax dues, that is on 36 lakhs so and so.
So this is like simply a delayed payment, so interest on a delayed payment. This is because in installments will be delayed payment.
Delayed.
Right. So this is not like a charging section.
And the order itself says that is subject to final adjudication by this Honorable Court in the batch of writ applications pending.
Right.
But they are demanding, sir.
But the demand is all there, we have paid.
Demanding 12%, my lord. There is no provision.
No, actually, this can be explained as money deprived. Money in your hands, which you have to pay the government, the more you retain, the more you enjoy interest.
Lordship is correct, but that money was not within our hand. It just is the case where the collection was
after
not.
28th March. See, the question is, after 28th March, every additional day, it's still money in your hands.
No, this is
when you're paying in installments.
But this is for the previous period.
Sorry for the interest. It is just like compensation, my lords.
That's right.
Interest is just like compensation.
Correct.
Now the moot questions which already has been framed by your lordship is that whether it is pre that date
28th of March 2017 or
post.
After post.
Correct.
That is the
No,
moot
he's now
question.
arguing the post.
Yes.
scenario.
Now we are saying that I think my learned senior will also agree. We are on this question alone.
Yes, that's right.
That is the whether interest will be levied pre 28th of March. That the two words my lord will mark
Sufficient.
tax due and payable and sufficient cost. These are the three words. Tax becomes due. This 2/3 amount becomes due to be paid when the Supreme Court has delivered the judgment and becomes payable immediately. Now, if there is a delay, I will pay that amount installment in any manner. But certainly not pre 28th of March. That is all my submission, and rightly your lordship has framed this question. This is the sole issue to be decided, whether pre or post. This is because, my lord, with great respect, this is a compensation, as if we are holding the tax.
Correct. And not
compensation.
And you're benefiting from how much you held.
Yes. And your lordship will remember that Brewery's case 79 ITR, where the Supreme Court said about this interest. It is not couched like 234 A, B, C of the income tax, and when we are not paying the advance tax, that automatically interest is leviable. It is not couched in that language, my lords. So this is the difference.
This is compensatory in fact.
It is compensatory in nature. So therefore, my respectful submission is the moot question to be decided, as has been framed by this honorable court, is whether I am liable to pay this interest from the date of it. And it is agreeable. It is agreeable, yes. But only the thing is that how much delay? How much delay? And you have to pay it.
What is the rate of
Rate. That's all.
All right.
And whether that rate will be borrowed
In my cases,
they have
immediately after the delivery of the judgment of the Supreme Court, they hurriedly pay the amount.
Yes.
Interestingly, they have borrowed the interest from this judgment itself.
Right.
From nowhere else.
Right.
So that is subject to your lordship's adjudication.
All right.
Rightly framed. This question has been rightly framed.
Compensation means not 12%, my lord. They are charging 12% as per the interim order of this honorable court.
All right. Yes, you have to add something.
One point I wanted to clarify, Lordship, your Lordship was looking at a higher judgment.
Yes.
Food Corporation of India.
Correct.
Where your Lordship was inquiring that state has not filed appeal. But here is a case, interestingly, out of the judgment of the Reliance judgment 2008, both the state and the dealers, both of them they approved Supreme Court.
Correct.
Para 30 is concerned for Para 30 which went in favor of dealers. Whereas the state went in appeal before the Supreme Court mirrors. Essentially filed before Supreme Court. So far as the virus of the enactment is concerned, mirrors, the dealers mirrors, they approved the Apex mirrors. So appeal was by both mirrors.
Correct.
Second point, your lordship will find all these cases, mostly my lordship concerned in these batch mirrors. But the demand has arisen from out of Form E24 after the Supreme Court judgment dated 2007 mirrors.
Correct.
2017. And with each 24 that has been issued to the dealers mirrors, there accompanies a notice of demand in Form E8 mirrors for recovering the tax mirrors, tax and interest mirrors as well, both tax and interest mirrors. If our lordship will see E8 mirrors, E8 is issued purportedly under Rule 16 of the Orissa Anti-Tax Rules mirrors. Now let us kindly see what section Rule 16 each mirrors. Rule 16, if my lords will see for a while. Order of assessment and notice of demand. The order of assessment under rules 15B, 15C, and 15D shall be in Form E7, and the notices of demand shall be in Form E8. This is precisely what Rule 16 says, mirrors. So therefore, the notice of demand, which is issued alongside this E24,
has to be preceded by orders of assessment.
Correct, mirrors. These are the, and what 15 B, C and D speaks, either it must be assessment or reassessment. My lords. So in all these cases where determination of tax is made by an assessment order, that is to accompany with a notice of demand in form A8, which contains the details of demand raised, interest imposed, and giving 30 days time to the applicant to go for appeal, if any. That is the context of this form E8 is belongs. Here, what they have done after Supreme Court judgment, they have recomputed, and on the basis of recomputation, they have incorporated demand in E8 belongs. So there is no determination of liability pursuant order of assessment. That is only recomputation pursuant to Supreme Court judgment. And your lordship have already seen whereas the scope of 7.5, which is at the stage of scrutiny of returns, belongs. If your lordship reconciles the provision of section 7.5 alongside 7.10 and 11, whereas that is at the stage, because every return passes to some stages, whereas when a return dealer is obliged to file return, that is, and the language is each and every return filed by a dealer shall be subject to scrutiny, either system-based or manual, mirrors. And rule 10 and 11, sorry, subsection 10 and 11 of section 7 provides the assessing officer who has the authority to answer. He has to go for scrutiny. And at that stage, if any tax is found to be due as per return, not paid, if he has not complied with or incorrectly claimed deductions, in those cases, he will have a determination after giving up. Then there is a provision for opportunity of grant of hearing.
Yes, serve a notice on the
exactly. So those procedures will follow. Then there will be determination. After determination, there will follow a demand. So now, can that stage be equated with a stage where post 15-20 years when Supreme Court judgment came, by invoking 7.5, we can say that we are scrutinizing your return after Supreme Court passes the judgment. Can that be purport or comprehension of this?
No. The only point, Mr. Sahu, is like I was mentioning earlier, these kind of procedural points will still not answer the main question whether you're liable at all.
Absolutely correct. I agree with your lordship. That is why our main focus of your lordship is without sufficient cause.
Correct.
That always means that is the only
cause. Just tell me one more thing.
The liability only arises, my lords, on 28th of March.
Right. No, just tell me one more thing. Under 7.5, the rate of interest was earlier 2% per month.
That after post 2012, it is 1%.
1%. No. Are they raising the demand for the post 28th March on the same rate?
Yes. No. They have modified 1 to. They are imposing 1%.
No. So this 1% is what they're applying. Yes. Even for post 28.3.
That's our answer will be, my lord. Interest cannot at all be imposed by applying 7.5.
No. That is argued. That is argued.
No, one more, because one actually parliamentary provision, my senior Mr. Mishra placed your lordship section 50 of the OVAT Act. I will place your lordship parliamentary provision which is not there in the act, and that cannot be comprehended by imagination that such a provision is there for levy of interest. That is 13C. Whereas a provision is there under 13C Orissa Sales Tax Act. Whereas for levy of interest, if your lordship will see the entire scheme of entity tax law, barring 7.5, there is no other provision contemplating levy.
No, my lord's query is the interest 1% is levied for the amounts which have
fallen due after 28th March.
Yes. After
Yes.
That
is
or 2% for the
no. Your lordship, what your lordship may mark, my lord, it is 1% per month.
That's right. I know.
So it's a compounding thing.
Correct.
That's why, my lord, for balance equities, the other judgment which the commission
amount relating to 2010 to 2017, which fallen due after 2017. 1% or bifurcated 2%.
No. It's all 1%. But what the commission has done, my lord, following this court's order, where this honorable interim order, my lord, where they have said that you pay to 12%. So the statute, my lord, does not prescribe of a 12%. It is 1% per month.
Per month.
So it may go much above 12%.
All right.
So now, so far as 13(6) of the Orissa Sales Tax Act is concerned, if a notice of demand is issued as a consequence of assessment made, a dealer is required to make the payment of tax within 30 days from service of the notice. Or he may go for appeal.
again for further appeal and revision before this annual court. And as per 13(6), whereas the amount ultimately found due, if not paid, shall attract interest liability.
Correct.
So therefore, whereas until then, interest liability cannot be ascertained.
Yeah.
That is the scheme under Orissa. So far this act is concerned, barring 7(5), there is no, and as my lords knows, be it India Carbon, whereas other two judgments, JK Synthetics, and so also Miller's, all judgments, whereas interest admittedly, whereas is a legislative function, which is a substantive provision. Whereas in absence of any substantive provision, interest cannot be imposed by any other mode. So here 7(5) is the only provision. And that has limited scope. It doesn't provide for belated payment of tax. That's after so much of years. That's like 13(6), which is not there in the Orissa Anti-Tax Act. So therefore, my only humble sum of lordship is there being sufficient cause exists in this case because of operation of interim order by your lordship. We have to comply with your lordship's order. And we succeeded in 2008, that went on till 2017, and it is not that state did not, we all both went in appeal for the apex court. So therefore, even though the ultimate decision dates back to the legislation, that is there, but still 7(5) clearly postulates liability based on sufficient cause. And Honorable Apex Court protected also saying that you pay this much so that balance will not be recovered. And that will not be a tax, that will become deposit. In view of all this, our humble submission of lordship will be that sufficient cause exists, at least. And if any amount is not paid after Supreme Court judgment, then your lordship can think of directing to pay compensatory interest. Compensatory, not under certain, not 7(5). That is your humble submission.
May I submit, my lord? I have one few little submission, my lord.
Yes, please.
This really, in my case, a little different. In that case, though I have an order in my favor by the Honorable High Court, that was not challenged before the Supreme Court. My order, specifically, I was not a party. So far as the group of cases, the interim order was passed, then not applicable to me because I was not a party to that case.
No, not a party, meaning the state did not file an appeal in your case.
Yes, my lord. One. Secondly, though I had an order in my favor.
No, which is your case now? Which is that?
My lord, that is one WPC. That is an item number 4 in the supplementary list today. Item number 4 and 80.
All right.
Item number 4 and 80. And I have not.
You give a note, specific note. Otherwise, it will be difficult for us to keep track.
Yeah, and I have not collected tax. And just one decision, my lord, relating to the penalty, because if I have not paid without sufficient cause, that amounts to willful disobedience. And that is also applicable so far as penalty is concerned. In 1970 Supreme Court Hindustan Steel case, para 7, I will just read one line, my lord. Even if a minimum penalty is prescribed, the authority competent to impose the penalty will be justified in refusing to impose penalty when there is a technical or venial breach of the provisions of the Act, or where the breach flows a bona fide belief that the offender is not liable to act in the manner prescribed by the statute.
No. So have you started? No, 1 minute, sir. Have you paid after 28th March? Have you paid or not?
Yes, I paid the tax after 28th March. In fact, in one of the case, under mistaken belief fact, I have paid even 33.3% also. Though I had an order in my favor.
De facto, you have accepted whatever they did for the other matters.
Other matters, I followed whatever. I followed just Mr. Mishra's arguments.
All right. Mr. Mohanty, do you have to make any submissions?
I have, Mishra has committed, covered, but I wanted to point out only one thing. You will also find my note I have given at page 12, you will also see.
Yes.
There is a difference. Section 7(5) provides for, without sufficient cause, pay the amount of tax due.
Yes.
And the other language is fails to furnish the return. Here, the other failure is not with sufficient cause. And there is no hearing for section 7(5).
Correct.
Whereas section 6, subsection 6, they say without sufficient cause, but give them an opportunity of hearing.
Right.
So 7(5) adjudication, there is no way where I can give my explanation.
Right.
So therefore, if you take it as a charging section, then without giving a hearing, the section itself cannot be worked out. Mr. Misra has said, I agree with him. The other point which I had raised and told before your lordship, that they have covered it, but section E24 has to have a prior E22 and V23, the judgment I have given to your lordship.
Yes.
Now, the procedure is that I said that 7, 10, and 11, scrutiny and subsequent, that procedure has not been followed. Now, they start in place of, they could have done a scrutiny after the Supreme Court judgment, but they did not do the scrutiny and they did not follow the procedure, as a result of which the orders have come. Now, here in this case, I had come to your lordship and your lordship had directed me to go by and file. No revision is paid there, but by direction of your lordship, I have gone there. Now, the commissioner says that the order of your lordship's court is rejudicative for me to go before him. But then one more thing I would like to point out to your lordship. The Income Tax Act exactly says this. 271, your lordship turn to page 13 of my note.
Yes.
That is subsection section 270 takes for 3 types of default.
Yes.
To fail to furnish a return, comply with notices, concealment. But coming to non-furnishing of the return, your lordship find 271 1A has without reasonable cause failed to furnish the return of its total income, which he was required to furnish under subsection 1 of section 110 voluntary return by notice given on section 132, section 148 were escaped assessment as reasonable cause, and he without reasonable cause failed to furnish it within the time allowed. So all these things were saying without reasonable cause, fails without reasonable cause, fails. And fails without reasonable cause would not be the same thing. It's not Sanskrit that you put any word here and there, it has the formation is there.
Changed. Correct.
So therefore, your lordship, when the burden is on the revenue. After the revenue discharges the burden, that my failure was without sufficient cause, then I will place my matters so that he could say that, yes, I accept this. I have given this notes in my some of the judgment, and particularly judgment your lordship and see. I have summarized it.
Mr. Mohanty, actually, in all your cases, the defense that you will put up is the same, namely that we had a judgment in our favor by the High Court, which got overturned only on 28th March. So we all had sufficient cause not to pay. That must be the uniform explanation all of you will offer.
But the question is the procedure they have to follow.
No. So what will happen is, Mr. Mohanty, if I agree with you on this point and I don't decide the sufficient cause point, I'll only postpone your misery. You will end up much more when you ultimately lose. You have to take a call. You want to decide this entire point only on procedure and not on the substantive point.
No, I'm saying substantive point also. And
no, if you don't, because it's the same substantive ground for all of you. Namely that you had sufficient cause because of the judgment being overturned only in 2017.
We are all in agreement with the lawsuit. We don't want to carry our measures further.
Because already one judgment is
correct.
There, setting aside E24. So that will end up again, as my lord has said.
We'll be down further.
I have raised an issue here.
Very little bit hope.
I have raised an issue here, my lords. Things to be done in a manner provided or not at all. And at page 21.
Correct. Mr. Divedi will be very happy.
He will say, yes, yes, we'll follow the procedure. You please send them all back to us. We love to hear all their arguments.
No.
And we'll pass detailed orders in each of their cases, he'll say.
Well, it will be like 148A. Your lordship will follow Ansul Jain and
all right.
And lordship will overrule our argument. And that is no, I argued that it is not a precedent, but your lordship have overruled my argument. We don't want further another Ansul Jain.
My lords, if I may submit on the appearing in
I think you're not audible.
Just
yes, now you are.
Yes, I'm sorry, my lords. My lords, I'm appearing in petition C number 28122 of 2020.
Yes.
Of 2020.
Yes.
My lords, this is a Sony India versus State of Orissa. In this case, my lords, the notice that we have received.
Yes.
We have received the notice in the year, our notice was received in 2019. December 2019 is when we received our notice, which is annexure 4 of our paper book. Now, in this notice that has been raised today on us, the interest that they are demanding is not from 2010 till 2017. Rather, they are demanding for only 6 months. That is from the date from March 2017. Just 2-3 dates, if my lords can note down, it'll be a little bit helpful because it's a little confusing. My lords, the original stay that we had received, my lords, the dates are like this: 17th of January, 17/1/2007, original Orissa High Court, Honorable Orissa High Court had held that this is not compensatory in nature. Then in 2008, they passed and they saved the enactment under Article 304A, which is the reliance judgment. On 3rd of February 2010, we got the stay order in our case, where similarly, as other petitioners had said, we were asked to make deposit of 1/3 of the amount, and they said it is not to be treated as tax, etc. The same language appears in ours also. That was on 3rd of, that was the original stay order, 3rd February 2010. Then May 2010, our writ petition in Sony India's own case in the Honorable High Court was disposed of following the Reliance case. That was May 2010. In July 2012, the SLP filed by the department in the case of Sony India, and my lords may just note the SLP number. There is a reason I'm saying this. SLP number 19199. It is 19199 of 2010. And we were stayed. At that time, we got tagged with the matter of Father William Fernandez. That is, there is another batch of matters in the Supreme Court. In November 2016, my lords, the judgment in Jindal Stainless Steel versus State of Haryana, the entry tax judgment was pronounced, wherein the Honorable Supreme Court, 9 judges had held the principles, and then all the matters devolved back to the respective division benches to be adjudicated and to see specifically for that particular state and in the facts of those cases whether the act is ultra virus or not. Now, the batch matters of Orissa, they were argued and the order was pronounced in the batch matters in the case of Reliance on 28th of March 2017. That is the State of Orissa versus Reliance. allowing the state's SLP. On 29th of March, there is another judgment, which is in the case of Bharti Airtel, again allowing the state's SLP. Unfortunately or fortunately, we were not, that is Sony India SLP 19199 was not part of either of these batches. Our matter got disposed of on 9 October 2017, 9/10/2017, along with the matter of State of Kerala versus Father William Fernandez. Now, the demand today, therefore, that has been raised is from the period of March 2017 till October 2017, that is the period of interest. In October 2017, when the judgment of William Fernandez was delivered, and our SLP, that is in the case of Sony India, state was allowed.
I think the question will be really, is the judgment in reliance a judgment in rem or judgment in personam? See,
Yes.
in batch matters, I think when the Supreme Court declares a law, it's very difficult to argue that because one stray matter got out of the batch and wasn't dealt with along with the batch, the law for that one particular litigant will be somehow different. I think that's going to be difficult to sustain such an argument.
My lords, I'm only
Because these are all declaratory judgments. See, declaratory judgments are different from judgments in personam, in adjudicating particular issues between parties. Declaratory judgments have it's like Article 141. A declaratory judgment means it declares the law. So it will be difficult for you to argue that somehow for your client, that law got declared only on the day your SLP got disposed of.
My lords, I follow what falls from
as far as I think the liability clock will begin commencing from 28th March 2017 for everyone, irrespective of whether one SLP got left out or whatever.
Yeah, my lords, the only difficulty that arises in such a case is, while the 9-judge bench can be held to be declaratory, whether when individually it has gone back to the division benches to be determined.
No, that individually it was not individual. See, again, those are batches. There is an Orissa batch.
Yes. Yes. Now, the only difficulty, additional difficulty is there was a stay order in my favor till 9th of October 2017.
That is the only thing that is helping you argue that you're not liable for these.
Yes. If there was no stay order, therefore, because there was a stay order in my favor till October 2017, that is the only reason why we are saying there was sufficient cause in me, not because immediately after the Father William Fernandez matter got decided.
So you had a further sufficient cause.
There was failure of sufficient cause. Yes. And my lords, only on the aspect of sufficient cause, I just wanted to cite 2 judgments, if I may just cite that.
Yes, please.
My lords, first is, of course, the judgment of JK Synthetics. So before I go to sufficient cause, just on the aspect of interest. So my lords are aware of the judgment in JK Synthetics, which is 1994 4 SCC 276.
That's right. They've all referred to it. Yes.
Yes. So therefore, para 9, para 16, and para 6. This is only to assist my lords with the proposition that, of course, in order to charge interest, there must be a charging provision for interest, even though interest is automatic. But you must still need a charging provision, number 1. Number 2, interest, while can be considered to be a machinery portion, is still treated to be a substantive provision, which is what I think Mr. Sahu and my learned senior Mr. Mishra also argued. So therefore, it is substantive. What turns on that, therefore, is in case I am not fitting the bill of Section 7.5 by implication today, or by widening the scope of Section 7.5, I cannot be fit inside Section 7.5. That is the only reason I'm relying on JK Synthetics. Para 6, my lords may only note, I'm not reading out, is also helpful in terms of understanding without reasonable cause. So that's not on sufficient cause. That talks about what is reasonable cause. But of course, that is something which is, since that judgment is already being referred to, I'm mentioning that. My lords, the second judgment I'm referring to with respect to sufficient cause is 2013 14 SCC 81. 2013, 14 SCC 81, which is Baswaraj and another versus Special Land Acquisition Officer. My lord, this was a land acquisition matter where the appellants there was delay in approaching the High Court, and High Court had dismissed on the ground that they did not show sufficient cause for condonation of delay. So while examining what is sufficient cause, my lords may note it is at para 9 of this. May I wait if the book is being brought to my lords, or it's just one paragraph?
You read it.
I'll read it.
Yes.
Yes. So in the context of condonation of delay, so para 9, my lords, para 9 and 11 I will read. Sufficient cause is the cause for which the defendant could not be blamed for his absence. The meaning of the word sufficient is adequate or enough, inasmuch as may be necessary to answer the purpose intended. Therefore, the threshold is very low. The threshold is it adequate? Is it enough cause? Therefore, the word sufficient embraces no more than that which provides a platitude, which, when the act done, suffices to accomplish the purpose intended in the facts and circumstances existing in a case. In this context, sufficient cause means that the party should not have acted in a negligent manner, or there was a want of bona fide on its part in view of the facts and circumstances of a case, or it cannot be alleged that the party has not acted diligently or remained inactive. Then paragraph 11, my lords. This expression, sufficient cause, should be given a liberal interpretation to ensure that substantial justice is done. But so long as negligence, inaction, or lack of bona fide cannot be imputed to the party concerned, whether or not sufficient cause has been furnished can be decided on the facts of the particular case. And finally, my lords, only one more citation. This is Banarsi Das versus Dalmia Dadra. This is a Punjab Haryana High Court, my lords, AIR 1959. Punjab and Haryana 232. And my lords, actually, I will not read it because it extracts the same portion from Baswaraj. The same enough and adequate. That is the portion that it extracts. So I'm not reading that, my lords.
All right.
So again, my only submission, therefore, is in my case, demand is not from 2010 to 17. In case, depending on the outcome of today's decision on sufficient cause, the same will apply, will apply to the state, whether or not they can demand that. But from March to October, because my matter had not been disposed, there was a stay order, which is dated 9/7/2012. In my own case, which was operational, it is for that reason we say we have sufficient cause when a stay is operational in my favor.
Yeah. All right. Kindly submit a note.
We will submit a note.
Right.
I'm extremely sorry. Before Mr. Dwivedi replies, because I have filed one IA 5968 of 2020 arising out of WPC 2521 of 17. So as per Lordship direction, without prejudice, I have deposited 1% interest bills. Now they have come up with another notice that you pay 2% and they have demanded differential 1%. For that, I have filed an IA bill. That I want to just bring to Lordship's notice. And I have prayed for not to take any action pursuant to that. Deeply obliged.
Well, one clarification. I've got 10 matters. Your Lordship may see one of the matters. Your Lordship say arbitrariness, as your Lordships initially held, that E24 notice. On a single day, they have issued E24 notices charging us the interest for the previous period. After the previous period, that is 2/3 amount. On that 2/3 amount, if there is a delay, therefore the interest was charged on the subsequent notices. So this interest notice was prior to this. Sufficient cause, my lords, one of the cause I would like to supplement here. My lords, my learned senior have all argued with regard to the cause that the interim order was passed. Interim order was passed and thereafter we have taken the benefit. It is not a question of taking the benefit only. We were also so moto deprived of paying the rest amount in view of the order passed by the Honorable Supreme Court. We could not have
so moto deposited, overriding the order of the Honorable Supreme Court also.
No. You could have filed an IA telling Supreme Court, I am very desperate to pay the entire amount. You could have filed an IA, sir.
No, my lord.
They would have very happily admitted such an IA. In fact, on mentioning itself, state would have agreed with you.
So 2/3 amount which was to be paid.
Yes.
My lords, that 2/3 amount after the order of stay was passed by the Honorable Apex Court.
Yes.
The SLP, many of the dealers that did not went, many of the state government did not prefer appeal against many of the cases. In my cases, we had appeared earlier, we had come before this Honorable High Court. And the Honorable High Court was pleased to pass an order of 1/3. And basing upon that, we had deposited 1/3. So it is not a question of that only the order can be confined to Supreme Court, Apex Court decision. This is also to be, the relief is granted to the other dealers who had appeared before this Honorable Court, and this Honorable Court, following the order of the Apex Court, had granted an order of 33 1/3. And basing upon this, we had filed a nil return. We were filing our return and it was a nil return. When the judgment came up in 2017, my lords, there was a high power committee which was also constituted by the state government, where we had also appeared before the High Court, where they had waived the question of penalty was waived. So far as interest portion, they decided it only for this 2017. So now they can not go back and say that you are also liable for the interest for this period. Because once a high power committee takes a decision, they took a decision prospectively. They cannot sufficiently go back and say that, no, now you are liable after this judgment to pay the rest balance amount of 2/3, that interest on this balance 2/3 amount.
All right.
If high power committee report, if it is placed before your lordship.
No, it's already in place. It's already in place. All right. All right. Mr. Dwivedi, do you want to reply today or on the next day? Because I don't think we'll finish today. Unmute, sir.
He's on mute.
You'll have to unmute.
Am I audible now, Vilas?
Yes, now you are.
So, I mean, your lordship's hands was entirely, Vilas, but I could just indicate, the line of.
All right. In the next 15 minutes, and then I think we'll continue on Monday if it's not inconvenient with you.
No, Monday is perfectly all right.
All right. Maybe we'll start at, if you can be ready from 2 onwards, but definitely we'll start only after lunch, not before that.
Yes, at 2 will be fine.
All right.
That will enable me to deal with the miscellaneous matters.
Yes.
Now, this entry tax has been a very long drawn battle.
It's still, pun intended, it still retains a lot of interest.
Yes. even though it's no more to be levied now, because of GST.
Yes.
Changes in the constitution, the entry is gone.
Yes.
So it's only the past.
Correct.
Which is of relevance.
Correct.
Now, as the lordships had put it to the petitioners, without sufficient cause, how do we look at it? How do we interpret it in the context of the Entry Tax Act? Will ultimately be the only question,
Correct.
The procedural part which they are raising, I wouldn't, of course, it doesn't hurt us. But it's really not made out at all. I'll place the provisions of law and demonstrate, that that's not sustainable. But before that, one, the case history I would like to straighten a bit. And 2, the provisions of the Entry Tax Act, I'll place them again in my own way. Now, with regard to the case history, the 2008 judgment of this court notices in paragraph 2, which is at page 56 of the writ petition. Lordship may not open it, I'm just need not open it because when the Entry Tax Act was made in 1999 and certain petitions were filed in this court. Now, those petitions were challenged basically on the ground, that the tax is not compensatory. in the light of Atiyabari and automobile transport cases which were laid down, this thesis. And this court, after examining the factual scenario, came to the conclusion that the tax is compensatory, basically relying on two judgments, later judgments, that is State of Bihar, Bharat Chamber of Commerce and Shriram Industries case. And it said that now there is a sea change. The Supreme Court used this expression without going in great detail about Atiyabari and automobile, that there is a sea change now and some connection, some nexus with the service render is enough. So this court followed those two judgments and upheld. So the law was valid. The point which I'm making is that on the first attack, the law was found to be valid by this court. The petitioners filed an appeal before the Supreme Court, which came to be considered with the judgment, with the case of Jindal Steels from Punjab and Haryana. And a bench of the Supreme Court then finds that there is a contradiction, that sea change business, they did not find quite, they were not comfortable with it. So they referred the matter to the Constitution bench. And the Constitution bench comes, that's, we can call it Jindal 1. Jindal Steel 1, they came to the conclusion that Atiyabari and automobile have laid down the principle of direct and immediate effect and not some connection. So they overruled that, those judgments of Bhagat Ram and Shriram Chamber of Commerce. And the matter came back to two honorable judges. Incidentally, Justice Kapadia was part of the Constitution bench and he was also part of the two judges bench when the matter came back. So His Lordships, Justice Pasayat and Justice Kapadia, they referred the matter to the various high courts to decide the matter again and submit their findings with regard to the compensatory character in the light of Atiyabari and automobile. That's how the high courts generally held that they are not compensatory. But so far as Odisha High Court is concerned, it said, though we have held it to be not compensatory, but we find that the law is valid, having been made with reference to Article 304A of the Constitution, which allows non-discriminatory tax to be imposed. Namely, if you are imposing tax X on goods coming into the state in the local area, and you are imposing the same kind of tax then on the internal goods, local goods, then it's valid and permissible under 304A. So this court upheld the validity of the act again in 2008. But there was a rider imposed that similar goods ought to be manufactured in the state also. So if, for example, tires are being brought in from Punjab and there are no tires being manufactured in Odisha, then you can't impose a tax on that. That was a small rider in paragraph 30. And when the state took the matter to the Supreme Court, the Supreme Court on the first day itself stayed that sentence of the High Court judgment in 2009 itself. So therefore, the entire act continued to be valid by virtue of that interim order. At no point of time, my lords, there was any doubt about the validity and applicability of the act. That's one part, my lord, which I wanted to straighten, my lord, and I'll show those portions of the judgment which are pertinent. The second thing is, my lord, that on the subsequent date, the court asked us to give a list of the persons like manufacturers and other dealers, etc., and what is the outstanding amount due against them. And on the next day, as the lordships have seen, and I'll reread it because certain portions have not been read out. The court, says that, all right, ad hoc amount for the time being you pay. Treat it as a deposit, not tax, but this ad hoc amount is being paid. They say there will be no penalty, but they don't say there will be no interest. There is an expression, clear express used, that the outstanding amounts without penalty. An outstanding amount obviously will be including the interest at that point of time till that. So therefore, outstanding amount minus penalty alone was to be paid in installments, and subsequent liabilities like ad hoc amounts were to be paid. So that's how the position is, and I'll show Mullard from after reading those orders on Monday, Mullard, that actually the court is only making an ad hoc arrangement. The liability, Mullard, since the para 30 was stayed, therefore the act continued to be valid and the liability continued to be fixed. An additional reason for this would be, Mullard, as I'll contend, that section, so far as 7.5 is concerned, under section 7.1, 7.1, your lordship saw, is a provision of self-assessment. Their assessment comes only when we don't accept the self-assessment. Subsequent provisions and rules relating to assessment, scrutiny, etc., it's not necessary that we should scrutinize. You have to file a monthly or a quarterly return and pay according to your return, which is self-assessment. And it's only when we don't accept your self-assessment, then the question of not further assessment, etc., will arise. So therefore, this is a case where an interest is being demanded on the basis of a self-assessment return filed by the petitioners, which indicates the full amount of turnover and also indicates what will be the liability, but says that we are paying only this much amount in terms of Supreme Court order. So at no point of time, Lord, the liability has been put in abeyance. Only an enablement is there by the Supreme Court that for the time being, you pay only this much, which will not be a deposit. The liability has never been stayed. So that's how, Lord, will be which I'll develop, Lord, on Monday, Lord, and when I play. So could we have it on Tuesday, Lord, instead of Monday?
Tuesday, all right. Tuesday is fine. Tuesday. I suppose Tuesday is all right with all of you. Tuesday is fine.
I'm grateful.
After lunch. All right.
Let's see, can I file the submission today or on that day, written notes of submission?
You can wait and I think I'd request the others who finished their arguments, including Ms. Lakshmi Kumaran and Mr. Udgata, Mr. Rajiv Ratha, all of you who've made this individual submissions, just to give your notes. It will be easier for Mr. Dwivedi also to answer. All right.
I'm grateful.
Thank you. Thank you.